Morning, everyone.
Good morning, Judge.
Good morning. How are you?
I'm okay. Mr. Jordan is going to be the litigation manager this morning.
Okay, get
All
Mr.
right.
Jordan. I'm special.
Good morning,
Haven't had
Your
him in a while.
Honor. Good morning, Your Honor.
Good morning. How are you, Mr. Jones?
I'm good.
Good. Are you going solo or you got some help today?
I have Miss Ryan as well.
Okay.
yes, too.
Okay. Good. All right. Let's see. I see the PDs. I don't see the jail yet.
Morning, Judge Mincy.
Good morning. How are you?
Good, wonderful. How about yourself?
I'm doing good.
Right. Situated here, just 2 seconds, Your Honor.
Okay, no worries.
Mike Posey, I'm going to have a social worker talk to him as soon as possible. He's never, every time I talk to him, he's a million years. He's not understanding the voices. Poor guy. Anybody bring the birthday cake to James Wallace, number 30?
Your Honor, we're gonna start with position number 27, Mr. Christian Thompson.
All right.
We're on
All right. Good morning, everyone. This is the state all-purpose calendar for August 3rd. And I'm Judge Regina Mincy, and we're going to start our calendar. Everyone listen to your attorneys. This court date, rather, is being live streamed and recorded on YouTube. So please govern yourselves accordingly and listen to your attorneys. And we have Mr. Michael Jordan with me today. So send all your paperwork to him quickly and expeditiously and early and all that good stuff, or else Mr. Jordan will come get you. So he has to get everything today, so we file it timely. Thank you. All right, we have position 27, Christian Thompson.
Hello, everyone. Christian Thompson here.
Okay, this is 23 CR 004482. And this is going to be, is this still going to be a negotiated plea?
It is, Your Honor.
Okay. State, what do we have?
Yes, Your Honor. So the state's recommendation is going to be 12 months to serve 32 days, credit for time served 16 days, balance probated 6 weeks of anger management, and a stay away from 1 Margaret Mitchell Square.
All right, Mr. McLean, is that your understanding?
It is our understanding of the terms. We do stipulate 3 necessary elements, and we ask the court to accept a negotiated plea of guilty.
Okay,
He has a hold to go to after this, Your Honor, so we, while we're on Zoom, we would forewarn the probation department that he's got a couple of holds to go to. So when we turn in the contact sheet, there will be a delay before he reports.
all right. And I think Miss Harris is on. Or,
He lives in Greensboro, North Carolina with his grandmother. So in Atlanta, he's residentially challenged, but as soon as everything's over with here, he will be returning to Greensboro and do his 6 hours of anger management from there.
all right. As long as we keep that address updated or keep in contact with probation, obviously, so that they will know where he is at all times.
Right, we'll hand them a sheet that's got their address, and they have a website. The website's sometimes better than the phone number, so it'll work.
Mm-hmm. All right, great. All right, are you ready, Mr. Thompson, to take your plea?
Yes, ma'am, I am.
All right, I'm going to ask you a series of questions to make sure you understand the plea that you're taking today and that it's free and voluntary, okay?
Yes, ma'am.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am, it definitely is.
All right, put your hand down for me. All right, and your attorney has stipulated to the venue, identity, and factual basis. Let me ask you the first question. Are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am.
All right, are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yeah, yes, ma'am, I do understand that.
And that you're giving up and waiving your right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
I do understand this. Yes, ma'am.
Okay. And has anyone told you that you'll receive a lesser sentence for pleading guilty today?
It has not been told any different from what he just described, ma'am.
Okay, that's fine. And let me ask you this, has anyone promised you anything if you were to plead guilty today?
No, ma'am.
Okay, and do you understand that if you're currently on probation, your probation could be affected by your guilty plea?
I do understand this.
Okay, and do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you? Are you freely and voluntarily entering into this guilty plea?
Yes, ma'am.
That's that final question on that form, right?
All right, and do you, again, to the charge of willful obstruction of a law enforcement officer, how do you plead?
Guilty.
And as to the disorderly conduct, how do you plead?
Guilty.
All right, I accept your guilty plea. You understand your terms and conditions, and you've got to get those completed and report to probation, okay?
Yes, ma'am.
All right, good luck to you. And I think that will complete that. Anything else, counsel?
Nothing else, Your Honor. Thank you.
All right, thank you.
Mike. Yeah, he can do that back there. Yeah. Thank you. I'll cover, yeah, do that back there and I'll cover over you.
Next, Your Honor, we're gonna go to position 24 and position 25. Ms. Angel Taylor.
Okay. All right, I have these as negotiated pleas, 24 and 25.
Yes, Your
22 22 CR 005929F, Angela Taylor, charged with 1 count of criminal trespass. And position 25, 23 FTA 000637.
That
All
will be
right, which is the
no
FTA, and that'll be no price. Got it. All right. Let's see what we have. State,
Yes, Your Honor. The state's recommendation is going to be 12 months to serve 10 days, credit for time served 10 days, balance probated, restitution, a stay away from 1612 Harvey Avenue, apartment 5 in College Park, no further contact with Mr. Hall, and 6 weeks of anger management.
okay. I see that. Is that your understanding, Mr. McLean?
Right, Your Honor, it is. We understand there probably won't be a restitution amount named. Somebody's grandfather replaced the broken window or windows. And this
Okay,
was,
so it's-
this was almost 3 years ago.
All right.
Thank you.
ASG Jones, that your understanding will take the restitution off since the window's been replaced now?
Yes, Your Honor, we can take the restitution off since the window has been replaced.
Okay. All right, anything else, Mr. McLean?
We just stipulate to the 3 elements and ask the court to accept the negotiated plea.
All right. All right, Ms. Taylor, can you raise your right hand for me? You affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
We got it.
Yes, ma'am.
Okay, yes, I need to hear you. Got to answer my questions to make sure you understand that you are pleading guilty today and that it is free and voluntary. So I'm going to ask you some questions, okay?
Ma'am.
All right, you can put your hand down. Are you presently under the influence of any medication, drugs, or alcohol?
Ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty today, you're giving up or waiving your right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving your right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you're prepared and agree to waive these rights today, is that correct?
Ma'am.
Okay, has anyone told you that you will receive a lesser sentence for pleading guilty?
Yes, ma'am.
No.
No, no, ma'am.
Okay, has anyone promised you anything to plead guilty?
No, ma'am.
All right, and do you understand that if you're currently on probation, your probation may be affected by your guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right, and as to the charge of criminal trespass, how do you plead?
Guilty.
All right. All right, I will accept the guilty plea and understand your conditions you to stay away from that Harvard Avenue and Mr. Hall
Yes,
and
ma'am.
do your 6-week anger management. You can do all that?
Yes, ma'am.
All right, good luck to you. I will accept your plea.
Thank you.
All right, you're welcome.
Just read that. Next, Your Honor, we're gonna go to position number 31.
Okay,
Todd Wilkes. Or is it Wilkins? Wilkes. Private Attorney Carlton Matthews. Is he on? Don't know. Got it.
this is 23 CR 004516Y. Tanya, is it Wilkes?
Yes, ma'am.
Okay. All right, you're charged with 1 count of theft by taking, and I understand that this is a plea. I had a private counsel. Is this not the case?
You have an attorney? I let him know.
I have a lawyer.
You have an attorney,
You want to call
Mr. Matthews?
Yes,
Okay, let's see. Is he there at the jail or is he on Zoom?
him? He's not at the jail, Your Honor. I thought he would be on Zoom.
We can simply look
Okay.
up the phone number and give them a buzz through the state bar.
Okay. Do you see him, Mr. Jordan, at all? No?
Go ahead, Judge. He hasn't filed an entry either on the case.
We'll probably have to circle back. I don't see him on Zoom either. Have you spoken to him recently, Ms. Wilkes?
No, ma'am.
And he would have, well, actually, he didn't enter, so Mr. Jordan, he would not have gotten a notice, correct?
That's correct, Judge.
Judge, I'll try to contact him and let him know he has a client on the sworn's calendar.
Okay, appreciate it. Thank you.
We can go to position number 26, Mr. Trayvon Taliaferro.
Okay,
Not you. You do? What is not? Okay. Your
all
Honor,
right, yes.
Mr. Talaferro has indicated to me that he'd like to change his plea to guilty. We did discuss what that would be if it's a negotiated plea. Was it the negotiated plea that you wish to accept? Was that the one?
I'll call this one 23 CR 004529D, Trayvon Taliaferro. Charge of 1 count of battery family violence, 2nd count of battery against a female who is pregnant. I see the state's offer. Do you want the state to read their offer again?
We understand the state's offer, Your Honor. It does involve 2.5 months of extra time in jail. Is that your understanding? Is that what you
Yeah.
wanted to do today? Okay. Well, we
Okay,
discussed the pros and cons of it, Your Honor. So he is indicating that he would like to accept their offer as opposed to making a non-negotiated plea or any other situation here.
All right, so you'll have to do the paperwork. Mr. Jones,
Yes, Your
ASG
Honor.
Jones, read the state's offer again for me, please.
Yes, Your Honor. So the state's offer is going to be 12 months to serve, 180 days, credit for time served, 13 days, balance probated, FVIB, a stay away from 3669 Bolfair Drive, that's BOLFAIR, Northwest, and no further contact with the victim, Miss Janiyah Shepherd.
All right, is that your understanding, Mr. McLean and Mr. Taliaferro?
It
Yeah.
is, Your Honor.
Yes.
All right, and Mr. Taliaferro, you wish to plead guilty with serving the 180 days.
Yes, ma'am.
All right, I'm going to ask you a series of questions if you're ready to take your plea at this time.
Yes, ma'am.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, and put your hand down. Are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am.
All right, are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
And by pleading guilty, you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
And so as to the charge of battery family violence, how do you plead?
Guilty.
And as to the charge of battery against a female who's pregnant, how do you plead?
Guilty.
All right, I will accept your guilty plea and you understand your conditions and terms, correct, that you must complete.
Yes, ma'am.
All right, good luck to you.
Position 23,
Okay.
Mr. Smith.
All right, it says hold for announcement. What are we doing on 23?
Your Honor, the terms change. We need to convey to the client if he needs to be defender. We need to convey to him the new terms that the state has proposed. We imagine that will probably be today, either a reset or further, or not guilty.
All right, 23 CR 004619A, Edward Smith. Does the state need to read its plea offer again, or?
We can, Your Honor, since
Okay.
it hasn't been confirmed. The state's plea offer is 20 months to serve, 24 months to serve.
So we'll discuss that with Mr. Smith and get back with the court later on that. Don't imagine that's moving today.
Okay, all right, so we will mark that as not guilty. He's been arraigned, I'm assuming.
Probably has in the past, Your Honor, but we'll certainly report back in a moment.
All right, so we're going to reset that, Mr. Jordan.
This is a newly accused case, Judge. He hasn't been arraigned on it.
He is not. All right, let me,
Very good.
you're gonna waive formal reading of the accusation?
Your Honor, what we'd like to do is reset the case in order to have a conversation with him in private.
Okay. Well, Mr. Jordan was saying he hasn't been arraigned. This is a 2023, March of 2023 case.
Correct.
So if you can either file a waiver of the arraignment, or I can do it quickly today.
We could do that today, Your Honor, but I would like to tell him what the old offer was, what the new offer is, and indicate to him what we think of that.
Right. Well, for the arraignment, I'm just going to tell him what he's formally charged with, and he can continue to talk to you.
Very good.
So are we waiving arraignment or are we?
Yeah, you're going to file the waiver, Mr. McLean, or do you want to bring him back to do the arraignment? I don't know if he's still there.
Right, I don't have his authority yet because I haven't conveyed that opportunity yet, but Your Honor, I can
The
convey.
authority on the arraignment? No, we're just talking about the arraignment.
Right, I've spoken to him, he wasn't available yesterday. So what I can do is speak to him on breakout or go upstairs or reset it. Today.
Oh, he's not there in the courtroom.
No, he's not here with me.
Okay,
He can
I'm
file
sorry.
the-
I misunderstood. I thought he was.
He's at 5 North.
Oh, 5 North. Is that him there or that's someone
Yes.
else?
Right, so after court, I can fill out a visitor slip and actually. see that.
Okay, that's you, Mr. Smith, and 5 North with your hand up.
Yes, ma'am.
Okay.
I'll speak to you for a second before you,
Not today, not right now. We do have several things to discuss, Your Honor.
All right. So we're just going to accept your not guilty plea right now, Mr. Smith, until you're able to speak to your attorney to go over the state's offer, okay?
yes, ma'am, but I need one question, if you don't mind.
Your attorney may not like it. It depends on what that question is, because
I
it
would-
may be a question against your interest, so be very careful.
Yeah, I'll be answering questions in private,
I would like to ask you a question, Your Honor, if you don't
not
mind.
on Zoom. We're not going to do questions and answers. No. Thank you.
No, I would like to ask you a question, Judge, if you don't mind, please, ma'am.
What is the question?
I would like to ask for a bond or a bond reduction on this case right here, ma'am, because I don't have a bond for one charge and I have it's kind of crazy, like a high bond and I don't have a bond on one charge.
Your Honor, I'm sorry.
This person, I think, is speaking of charges which are not on our calendar. So I can explain it to him, and that's why we don't do Q&A during the
So
session.
these are the charges that we have on this calendar, on this arrangement, the battery and the damage to property.
So Your Honor, if I may chime in,
Yes.
he does not have a bond set on a simple battery family violence and the cruelty to children, which is what's on today's calendar. I think after opposing counsel has kind of brought up the authority and whether he has the authority to waive arraignment, I'm also wondering if he has the authority to acknowledge a reset. So I think if we could just move this to the back of the calendar, give them some time to discuss this, and then we can just come back after. That way we know exactly what it is that we're doing and
Right.
we're able to move forward.
Right. We'll give you some time, Mr. McLean, if you can talk to him while he's here today. I'm not comfortable just resetting if we don't have a bond nor an arraignment. I want to do either or, both bond and arraignment, or either a plea or not guilty plea. So if we could put this to the end of the calendar, give you a second to talk to him and explain to him the process and the procedure, then we'll see what we can do today, if anything, okay?
That's exactly my point. Thank you.
Your Honor,
Yeah.
Your Honor, this is Officer Norris in courtroom 2.
Yes,
The only issue with that is that officer up there, he's a roving officer. He has to go to all different floors to pull the defendants out. So it's gonna be some time before we even get back to 5 North, if we can get back to 5 North. Hopefully it doesn't run into the misdemeanor.
oh, to the other, yeah.
Exactly.
Is there any way Mr. McLean can talk to him on the phone? Do they have a phone up there?
Mr. McLean could probably do a breakout on
That would work.
Attorney Dotis' laptop.
That's fine.
Okay, if they can do a breakout, I don't know if it'll hold us up from the other cases, because I understand.
I can go to Mr. Dotis' cases and Ms. McLeod.
Okay. If
And
we can do
Judge-
that quickly, Mr. McLean, since we
Judge,
may. Yes,
Before
Ms.
Mr.
Jordan.
McLean leaves, so he has a 20,000, this case was transferred from Superior Court.
Uh-huh.
He was given a $20,000 surety bond on the simple battery, and there was no bond assigned to the cruelty to children. So that's what
Okay.
he was talking about. So one of his charges, he doesn't have a bond on.
Okay, which is a cruelty and a 20,000 surety on the simple
On
battery.
the simple battery, yes. Then the case was transferred to Superior Court.
Okay. All right, Mr. Smith, you're gonna talk to Mr. McLean in a second so that you all can communicate with your attorney, okay? All
Can we do position 1, Mr. Adams on 3 South?
I think so, if Deputy Norris lets me do it.
Your Honor,
That's fine, Your Honor.
Okay,
Your Honor, I hate to add to the trouble, but I will need to have a conversation with Mr. Adams on my laptop at some point as well, or if there's a phone on 2 South.
do you all have a phone up there?
Yeah, I didn't think so.
Not on 3 South, no.
Your laptop is the hot laptop, Mr. Dotis.
I understand, Your Honor. We need more laptops.
Do you have anyone else we can?
I can go to Ms. McLeod's cases.
Okay.
Position 19 and position 20, Mr. LaCory Rowe.
Okay. Good morning, Mr. Cloud.
Good morning, Your Honor.
All right, this is 19 and 20. We have, is it LaCory Rowe, 20 CR 0030997C, charged with 1 count of simple battery, and then the FTA on the second case. It's a no process. Is this still going to be a negotiated plea?
Your Honor, it's going to be a non-negotiated plea.
None, okay.
Yes, Your Honor.
All right, state, what do we have?
Do we want to hear her criminal history first since it's non-negotiated, Your Honor?
Yes, I'm sorry, pretrial.
Morning.
Good
Your Honor.
morning. Good morning.
The defendant has 12 arrest cycles beginning in 2014. There is a misdemeanor conviction out of Fulton County for theft by taking and simple battery family violence. Disposition date is June 2018. It's another misdemeanor out of DeKalb County it was a terroristic threats and acts that was amended to a disorderly conduct. That was in November of 2018. 1 FTA, and it appears the last arrest was for a violation of probation out of Fulton County, March of 2023. Nothing to add, Your Honor.
All right, thank you.
Yes, Your Honor. So this incident occurred on November 6th of 2019, where police were called to 2328 Campbellton Road, Southwest, apartment AA7, where the victim, Miss Fowler, told officers that her former boyfriend, Mr. Rowe, crossed the street when she got out the bus. She decided to ignore him. He then punched her in the head. She stumbled as he continued to punch her in the head. She lost one of her shirts, Your Honor, in the process of the scuffle with the defendant. The officer did observe that her undershirt appeared to be stretched and her hair was messy. Your Honor, you have just been informed of the simple battery family violence from 2018 conviction of the defendant, which is, again, we have a battery family violence. This time it's getting worse as there was visible bruising, the disorderly conduct. Also, there is an arrest from 2020, which is a robbery and a false imprisonment, which was put under the First Offenders Act on 3/12/21. So, Your Honor, there's also another arrest for a simple battery family violence in 2020. There's an FTA from 2018. There was an ag stalking dismissed from 2017, a battery dismissed from 2015. So, Your Honor, this defendant has a habit of putting his hands on other people. Therefore, the state's plea offer was 12 months to serve 90 days, credit for time served 16 days, balance probated, FVIB, a stay away from 2328 Campbellton Road, which is the Apple Tree Townhomes, and no further contact with Ms. Fowler. I'm not for sure if she's on, but at the appropriate time, if she is on, if the court could sound for her. Also, in 23 CP 220532, the defendant has a $10,000 good bond, which is a marijuana and a theft or receiving stolen property charge, Your Honor. Nothing further from the state.
All right, Mr. Cloud.
Yes, Your Honor. My client is 26 years old. This incident, according to the report, happened about 4 years ago. I have spoken with my client and he tells me that he no longer has any contact and has not had any contact with Miss, I'm sorry.
Fowler. I think it's Fowler.
Yes, Miss Fowler. He's not had any contact with Miss Fowler about since the time this incident happened. So it's been about 4 years since he's had any contact with Miss Fowler, Your Honor. He also tells me that he has some illnesses, some disabilities for which he receives SSI. He's not able to work. So he is challenged in many respects. And I think that is something that we ought to take into consideration. And he's told me that he's had these issues for which he has to take medication. And at the time when this incident allegedly happened, he had not been taking it, but he tells me that he is taking it now. He tells me that he does not live in the Metro Atlanta area anymore, that he lives in Argonne, Georgia with his grandmother. He's been living there and things have been going well for him there, Your Honor. The issue that I have with the state's plea offer is that, for one thing, he has to serve more time. So it is not a time served offer. And also, the state is asking for a year of probation. Probation is going to be difficult for him because he does not live in the Metro Atlanta area. We do not have an issue with I believe it's an anger management course that we're asking for him to do.
FVIB. I think it's FVIB.
Yes, we do not have a problem with that, with the course, Your Honor. But what we would like is for his probation to terminate after he takes the course and for this to be a time served offer. So that is why it's not negotiated. Those are the issues that we have. The length of times that the state is asking, the 90 days, we'd like it to be for the time he has already served.
Which is 16 days?
Yes, Your Honor.
Let me ask this. Where did you state he was going to be living with his grandmother? What part of Georgia?
Argonne, he tells me. Argonne, Georgia, Your Honor.
It's always a new one. I don't know that I've heard of Argonne, Georgia.
I had not heard of it either, Your Honor, but it is definitely not in the metro area. I'm going to have to look that up.
Right. You know, I do have some concerns. His history is certainly not good. It does concern me, as the state has stated.
Your Honor, if I could just briefly address Ms. McLeod. I do understand that this happens a couple of years ago, but I want to go through the procedural posture in which in 2021, this defendant was set for a possible plea in absentia. That fell through. And then he was actually set for jury trial on 6/13 of 2023 in front of Judge Morrow, in which he failed to appear. So, and given that this originally happened 5/5/2020, you know, we're in the height of the pandemic. So at that time, that is the reason for the delay of why we are here today. So I just wanted to provide a little bit more clarity on that part.
I think he was incarcerated based on what he told me at the time. Certainly, that was what I got from him, that he spent a whole year in jail after that incident happened. So for him to spend more time because of that same incident, that's what he tells me, that he was in jail for about a year.
Looks like ASG Jones may be checking that. Can we see that at all?
I can't, Your Honor, because he wasn't in Fulton County. So, and she hasn't provided where he was at the time.
Do we have any documentation or proof of that, Ms. McLeod?
I don't, Your Honor, and I see my guy putting up his hand up. Mr. Rowe, do you have any information about the time period when you were locked up?
Yes, the incident happened in 2019, and then I ended up again finding out, and then I got locked back up. So I spent a year after I found that, and stayed in jail a whole year. Then when I came to court, like a week later, I ended up seeing the lawyer for that case, and she never came back to me to see me for that case. So I stayed a whole year. So that's 9 months after she came to see me. So I've been had time to handle that case, but she never came to see me. So there's something on that lawyer end. That is, it's in the system. I stayed a year in Rice Street.
A year in Rice Street?
Yes.
That's what he told me, Your Honor.
Well, I'm just not excited about no additional jail time, and we can't get confirmation that it was either for this charge or some other charge. And I'm very, very concerned about your history, Mr. Rowe. You know, in the 2-for-1, it would be 45 days, give or take. But the only thing that I may do is
So, Your Honor, with complete candor to the court, since he did say that it was in Rice Street, I was able to pull it up. It looks like it was a probation violation, in which he did serve 108 days, and he was released on 6/9 of 2022. So if I go back to the FTA in front of Judge Morrow, that is 6/13/2023.
was just a few days later.
No, it was a whole year later.
I mean, a whole year. That was
Yes,
6/9/22, and then a whole year later. You know, the FTA for his trial and the plea in absentia both. And I don't know that he was locked up in 2021. And it looks like in 2023, he wasn't. He was just FTA for his trial.
I thought when I looked at the case, Your Honor, that the plea in absentia was in 2022.
I
The
thought the state
possible
said
plea and
twenty
extension.
twenty-one.
Yep, it was the possible plea and abstention was on January 19th of 2021 at 11:30 a.m.
Right.
And then what was the reason for the FTA?
The reason
Just June 13th of 2023.
Just based on what it tells me, Your Honor, it sounds like for some reason he did not have notice. I do have a good address for him now where he can receive his mail.
Yeah, I don't usually, it appears that there may be some issue of showing up, which is part of the problem. I mean, he's not telling me he was locked up in June, and here we are in August. And part of the defendant's responsibility is to keep an updated address with his attorney and or with the court while he's out. Only thing that I see based on his extensive history is maybe cutting it down, to maybe 60 days as opposed to 90 and then the 2-for-1. But I would be asking for some more time as well.
Your Honor, my client will accept.
That the 60 days?
Yes, Your Honor.
Okay. All right, so state, is that what we'll do? We'll do 60 days.
that's fine, Your Honor. Since this is a non-negotiated plea, of course, the state wants the 90, but we understand and we'll move.
Okay. All right, that's what we'll do. Ms. McLeod. So are you ready, Mr. Rowe, to take your plea?
Yes, ma'am.
Okay. All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, and Ms. McLeod, do you stipulate?
I do, Your Honor.
Okay, thank you. Excuse me, hold on 1 second. All right, Mr. Rowe, tell me this, are you presently under the influence of any alcohol, drugs, or medication at this time?
Oh, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
You gotta talk loud.
Yes, ma'am.
Oh, okay. And do you understand that you're giving up or waiving the right to remain silent and not testify against yourself?
Yes.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And has anyone told you that you'll receive a lesser sentence for pleading guilty today?
No, ma'am.
Has anyone promised you anything to plead guilty today?
No, ma'am.
And do you understand that if you're currently on probation, your probation could be affected by the guilty plea today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
And as to the charge of simple battery, family violence, how do you plead?
Plead guilty.
Okay, all right, so again, that's 12 months to serve 60 days, credit for time served, 16 days, balance probated, FVIP course, stay away from 2328 Campbellton Road, apartment A87, and to have no further contact with Cariana Fowler. You can comply with those conditions?
Yes.
Okay, all right, I will accept your non-negotiated plea. Anything else, counsel?
No, Your Honor.
Okay, anything else, ASG Jones?
No, Your Honor.
All right, accept your plea. Good luck to you, Mr. Rowe.
I have another client, Your Honor, Mr. Person.
Okay.
Your Honor, if I may make an announcement real quick, if I could please have my laptop put in a breakout room with 3 South, speak with Mr. Allen.
Okay,
Thank you.
Okay, will do.
Your Honor,
yes.
if Attorney McLeod don't mind, is it possible I can go, ACDC can go next because I have Ms.
Hilton,
Reed,
you can
right?
go. You can go. I said that already. You can go.
Thank you. Position 18, Ms.
Okay.
Reed.
Okay. This is 23 CR 004636C, Tanisha Reed, charged with 1 count of criminal trespass. And is this going to be a negotiated plea still?
Your Honor, we are at an impasse about one of the terms, one of the conditions in regards to the offer that was made by the state. And so with regards to that, we would like to leave that portion up to the discretion of the court.
Okay, and tell me your name, please.
Yes, Your Honor, for the record, my name is Samantha Adams. I'm with the Public Defender's Office.
Okay.
Yes, Your Honor. So in judicial efficiency, I'll just tell you what the concern is. We had an opportunity to speak with our victim this morning, and she states that she is not comfortable with the defendant being near her or around her home in the instance that she's not taking her medicine because she's a violent person. So we are asking for a no further contact and a stay away. And I think that the defense, and correct me if I'm wrong, is asking that she be allowed to stay upstairs with her.
Not stay. So Ms. Reed is 13 weeks pregnant, Your Honor. And the father of her children lives in an apartment upstairs from her mother. So even if the court decides to keep a stay away in place with regards to the complaining witness, we're just asking for permission for her to still be able to go to the apartment complex because the father of her unborn child lives there. So she can stay away from her mother's unit, but being able to still go over there and see the father of her child is what we're requesting.
Let me ask this. So Miss Nicole Howell is the mother to Miss Reed?
Yes, Your Honor.
Yes, Your Honor.
Okay. And Miss Reed wants to reside in the same complex with her child's father, but not in the same building.
It's
Is that correct?
It's not necessarily reside. She wants to be able to at least go over there.
Well, if she's going to be living somewhere else, why can't he just go visit her where she lives?
I haven't had an opportunity to speak with him, Your Honor, so I don't know what his situation is. It's just that, you know, Ms. Reed was just requesting the ability to be able to go over and visit him in at all. That's required, if that's allowed.
Well, I don't know how large the Hidden Lake apartment complex is. I don't suppose it's that large, but are we talking about 5 buildings apart or 2 buildings apart? I just don't want the victim to be further victimized, even though she may be her mother. But we've had an incident. This offense date was June 25th, correct?
Yes, Your Honor.
So it's pretty recent. This is not something 2 or 3 years ago where the parties have had time to get through it or cool off. I think there's been a sufficient general cooling off, but I am concerned that this just happened a month or so ago. I do understand that she may be expecting, but I'm not comfortable with her being able to just kind of, you know, casually go around this complex for the victim to continue to see her or be victimized by her presence.
Your Honor, may I give you some insight on that complex? I actually lived there in a past life.
Oh,
and
wow.
It's quite large.
Why a past life? A current life.
There.
And it is what, Ms. McLeod?
There are several buildings in there. It's a big complex.
It's a huge complex.
It's a huge complex. I lived there, I think, briefly when I was in law school for maybe about 6 months to a year.
Okay. Small world, small world. Yes. Okay. So that would be my concern, counsel, you know, is that now that Ms. McLeod has shed great light on this, if we're talking about a large complex, you know, you know, that 100 yards, 200 yards. You know, I'm wondering if your client can do that. Can stay away 200 yards or more from her mother.
If I may, Miss Reed, yes. Does he live directly upstairs? Is it far away?
I live directly upstairs from my mom. Like my mom is in 226. He's in 228. I spoke to my mom this morning and she even told me that she wants to be in my life and the baby's life.
But you're talking about upstairs. So I thought we were talking about a whole different building.
And we live in the same building. That's me being 100% honest. Like,
yeah, I appreciate your honesty.
And my mom has been taking care of me because my mental health. I have schizoaffective disorder, and my mom has been taking care of me since.
I understand, but your mom is the victim. I don't know if she's telling you the same thing she's telling the state. And
well,
I don't think
told me she spoke to my attorney this morning, and she did not.
She did not speak to me, but Ms. Reed, we're gonna just go ahead and let the judge go ahead and make her ruling, okay?
State, your victim witness advocate has spoken to the victim today.
That is, she spoke to the victim this morning and sent me those updated notes.
Okay, so there may be a little bit of a conflict here, but I do not know, and I'm not sure if I'm ready to put you two back together that close again. And I'm going to definitely make sure, because you've got a 6-week anger management course that the state is offering for you to take. And I would probably add to those conditions that you stay on any prescribed medication.
Well, Your Honor, with regards to that term, the state and defense have come to an agreement with, in lieu of the 6-week anger management, that she do a mental health evaluation and any recommended treatment.
Okay, so that's been changed, Mr. Jones?
Yes, Your Honor.
So is it MHET
Yes, Your Honor.
and whatever they order?
Yes, Your
I'm
Honor.
assuming she's presently under some type of physician's care. Is that correct, possibly?
Yes, Your Honor.
And Your Honor, that was only changed simply because we heard from the victim this morning. Given the nature of the incident, the anger management was a foregoing term. But since we heard from her this morning and she expressed her mental health concerns about her daughter, that's why we decided to amend that particular.
Okay, so let me ask this, counsel, Ms. Adams, does your client have somewhere else to go stay while she's on probation?
Yes, Your Honor. She has provided to me that she will first go stay at a hotel until she gets her next check so she can go get an apartment.
Because I just want to make sure that we're not back down here again. We don't have any more incidences. She can focus on her pregnancy, have a healthy pregnancy, but also I think there needs to be space between the victim and the defendant while she's on probation, at least, to make sure the terms are successfully completed. And by that time, she may end up being a mother.
Yes, Your Honor. Ms. Reed is aware that the space is necessary, and that's the reason why she conveyed to me that, you know, she doesn't need to go back there if she has to go stay at a hotel first until she gets her check, so she can get her own apartment, so she has that space, and so that she can have a healthy and safe pregnancy.
All right. And as far as the father of the child, he's going to have to come where you are, not the reverse. So you're not to go there and you're not to go visit him there. You know, he's going to have to come and visit you where you are. I mean, he can get around, can't he? Ms. Reed?
I think she's saying no, that he can't, Your Honor.
Is he
Meeting is being recorded.
he's not able to walk or get around?
She said no, Your Honor.
He's not. He doesn't travel. He doesn't like have a car. He doesn't.
Well, at this point, I'm concerned about your welfare more so than his. And I certainly want you to have support when it
Excuse me,
comes
Your Honor?
to your
Your Honor?
pregnancy.
You okay?
Yes, ma'am. But it's just because it's my mom and I don't want to deal with Oh, my
Well,
mom
you'll
been
be,
taking care of me because of my mental health.
Hang on,
I
Your Honor-
understand,
Your Honor,
but we, go
may I
ahead.
may I make a request?
Yes.
With regards to the MHET and her probation, Your Honor, if it pleases the court, after a period of time of her getting treatment, Your Honor, may she be able to petition the court to be able to amend her probation, to be able to have contact with her mother?
Always, you can always make that motion,
Yes, Your Honor.
to amend it, once we've had some successful months, you can make a motion to the court to amend, the probation terms, especially with her pregnancy, and I understand, and her condition. And she's definitely going to need the support, but we want to make sure that it's going to be a positive interaction and support, so that we don't end up here again. And so you understand my concern with that, as well as making sure that your mom will be safe and that you will do what you need to do, Ms. Reed, so that we don't ever see you again. And that's a positive thing. We always say, we don't want to see you back here again. And I really don't. You're young, got a full life ahead of you. Now you're going to have a huge responsibility, and that is having a baby. Is this your first child?
Yes, ma'am.
Yes. Okay. Life is getting ready to really change for you. And that's a huge responsibility. So we want to make sure that you're in the best state and place for that. And so is your mom. But I think you all need some healing and some assistance to get back to a positive space. Okay. So that's what we're trying to make sure of. All right, Ms. Adams, we'll do that. State that offer again, 12 months to serve, 37 days credit for time served, balance probated. And so she will have to do an MHET and any recommended treatment. And I'm going to add a condition on there to stay on any prescribed medication as well, if the MHET doesn't change anything. But regardless, she will stay on her medication and treatment plan.
And of course, stay away from the Hidden Lake Apartments of 4050 Morgan Road, Union City, and
Right.
no further contact with Miss Nicole Howell.
Right. And no further contact with your mom until we have amended any of the orders or conditions. If it's not amended, don't get in trouble by going around her. Unfortunately, you'll, have to do this for a moment to make sure that everything will turn out okay. All right.
And Your Honor, may she have permission to go with sheriff to go collect her belongings from her mother's home?
Okay, a one-time law enforcement escort to retrieve her personal belongings. And remember, that is with the law enforcement escort. You're not to go by yourself. You're not to go there and say, oh, I couldn't reach anybody, but I'm here anyway. Then you'll just have to go without until you can schedule that escort by law enforcement to go back there to get your items. It's for your safety, your mom's safety, so that you don't violate your terms of probation by going alone. Okay. All right. Anything else, counsel?
Nothing from defense, Your Honor.
Nothing further from the state, Your Honor.
All right. So Ms. Reed, you ready to take your plea?
Yes.
All right. Ms. Adams, you stipulate?
Yes, Your Honor.
All right. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay, I've got to hear you. All right,
Yes.
put your hand down. Are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No. No.
Are you satisfied with the services and representation of your attorney?
Yes.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're currently on probation, your probation could be affected by a guilty plea here today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
And so how do you plead to the charge of criminal trespass?
Guilty.
All right. I will accept your guilty plea. You've heard the terms and conditions. And I wish you good luck and also good health with your pregnancy, okay?
Thank you so much.
All right, you're welcome.
Position 1, 3 South, what's the notice client?
All right. We've had a chance to, this is Mr. Adams.
Yes, ma'am, it is. Ma'am, yes.
Okay, 23 CR 004639A.
And Your Honor, I sent a message in the chat asking if the ASG was for position 1. I would request no further violent contact based on what Mr. Adams has told me. That he wants, it sounds like him and his wife want to reconcile, so I just wanted to reach out to see if the state has had contact with Ms. Barber.
Our state, have you had any contact with the victim, Ms. Barber?
Your Honor, let me confirm that one quick second. Yes, Your Honor, we have had contact with the victim on this particular case.
All right, and what is the victim, her position?
Yes, Your Honor. So she actually agrees to the offer that included the no further contact.
Not no further violent contact?
Not no further violent contact.
Okay, counsel, doesn't sound like we have an agreement on
Right.
no further violent.
Understood. I would just ask Mr. Adams, we did discuss the offer, what it might be. Do you want to go further forward with the offer, knowing that it's no further contact? We can unmute 3 South.
He talking to me? Mr. Doty, he wants to know when you talking to him.
Yes, Mr. Adams, do you want to go forward with the offer that we discussed with no further contact?
Okay, that means I can't be with the woman I've been with all them years. Got to leave home.
Mr. Adams, hold on, Mr. Adams.
That means that.
If we want to keep talking, I'm happy to go back in a breakout room with you.
Okay, then whatever y'all think is fair.
Does he have somewhere else to go stay?
Yes, I got plenty of places to stay.
And
I go back to Ohio. And then let the state take care of it.
Your Honor, I did speak with him. He does have a place in Ohio, but he does know he needs to contact the probation office.
I got places in Marietta, home Georgia.
Right, but it sounds like he still wants to go forward with the negotiated plea. So at this point, that's what we'd ask.
And so you understand, Mr. Adams, it will be no further contact with your wife, so you will have to stay somewhere else. Wherever you stay, you will still be on probation and you will still have to report.
I never will have a chance to see her again, right?
I don't know about never while you're on probation, which would be 12 months.
Well,
after the successful probationary period is over, then you can try to reconcile at that point. But while you're on probation, you cannot.
I can't give her no money or nothing, right? I get a check. I can't give her none of that.
I am not your attorney.
Mr. Adams, Your Honor, I'd ask for a breakout room just to make sure we clarify this before we go forward.
Please.
Thank you.
Because if he doesn't understand the plea, I don't want to take the plea to get him in trouble and he can be arrested.
I understand it. I'm not gonna get arrested no more. I haven't been arrested in a while. I understand what I'm saying, ma'am. I understand it.
Because you've got a 24-week program that you have to complete while you're on probation that would require you to not have any contact.
Where would that be located at?
I don't give out that kind of information. Your attorney can tell you. The problem you're going to have is if you're in another state, that will make it complicated.
No, I'm gonna stay here in Georgia.
Stay in Georgia.
Be in the city.
He'll give you that information. He'll give you that
If we get out of
information.
court, Mr. Adams, I'll come up and provide you with that information physically and go over any additional questions.
So what would you all like to do at this point?
I like to do what he says, ma'am.
All right, so we're taking a plea to the terms as stated. Let the state go over them. Did you state them, Mr. Jones? You may not have.
I did not, Your Honor.
Okay, go ahead and state those terms.
Yes, Your Honor. So the state's plea is going to be 12 months to serve 143 days, credit for time served 143 days, balance probated with an FVIB, with the FVIB program, stay away from 65 Chapel Road, Atlanta, no further contact with Carol Barber or her nephew, Akoy Motion, and that's AOKI Motion.
All right. Is that your understanding, Mr. Dolders?
That's our understanding of the plea, and that was the offer that was conveyed. We do stipulate to the factual basis, venue, and ID for the purpose of this plea. And I believe it all should merge under count 3, if I'm correct, based on my understanding of.
So we would have a plea to the simple battery and the battery, that's it?
So it would be battery, family violence, and then the 2 other charges would merge into that.
Oh, okay, so just
yeah,
one
that's how my
count
paper
of battery,
reflects.
family violence, and the other 2 would merge. Is that your understanding, Mr. Jones?
That is not my understanding, Your Honor. I
No?
understand the simple battery merging to the battery, battery family violence, but the battery itself, if we can hold for 1 second, it's fine. It's fine if it merges, Your Honor. That's fine.
Well, tell me, double check.
Yes, let me double check really fast. Sorry, Your Honor, I'm almost at the answer.
Okay, no worries.
Because all of these counts involve the same victim, Your Honor, we are willing for it to merge.
Okay. All right, so we're just going to be then pleading guilty to the, let's see. Let me grab it back. So we're only going to be pleading guilty then to the battery, 1 count of battery family violence. That's all, or 2 charges?
Just the battery family violence.
Okay, to the 1, okay. All right, and so you're ready to take your plea, Mr. Adams?
Yes, ma'am.
Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. Are you presently under the influence of any unprescribed medication, drugs, or alcohol?
All prescribed, except alcohol.
Okay. Are you satisfied with the services and representation of your attorney?
Yes. Yes, ma'am.
Okay, good. Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
You're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And you are prepared and agree to waive these rights today?
Yes.
Has anyone promised you anything to plead guilty?
No.
Has anyone told you that you receive a lesser sentence for pleading guilty?
No.
And do you understand that if you're currently on probation, your probation could be affected by your guilty plea?
I'm not on probation.
Good.
Yes.
Do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
And as to the charge of battery family violence, how do you plead?
Guilty.
All right. So you've heard your conditions and no further contact with your wife until you're off probation, okay?
That's be a year, right?
Yes. So I will, unless you get an order otherwise, okay?
Who can give me otherwise order?
Your attorney, you speak to your attorney, and if he applies for a modification and you get an order, then you'll get it. But if not, it'll be the 12 months.
A modification, that means.
Mr. Adams, we'll go over all of your options. I'll come see you as soon as I leave the courtroom, before I leave the building. I would also ask, Your Honor, if after speaking with Mr. Adams, he's currently retired, but I think he's going to have to get a job upon release. So we would ask the court to waive a few months of his probation fees and let him switch to non-reporting class, or excuse me, non-reporting status upon completion of the FVIP. That's a 24-week program. He has completed 143 days, so probation should close out shortly after that, but I'll go over that with Mr. Adams.
Okay, I will waive 3 months of his probation fees. And then he can go non-reporting after he's completed the FVIP. Okay? All right, you're welcome.
Your Honor, the state would just
Yes.
object to the non-reporting of the probation after the completion of the FVIP.
All right.
But I have to get another job. I retired. Do I have to get another job?
Speak to your attorney about that. Speak to your attorney about that. I'm going to go ahead and waive your reporting as long as you keep your address updated after you completed the FVIP program, okay?
Yes, ma'am.
All right, good luck to you.
Position 30, Mr. Wallace.
All right, position 30, 23 CR 004515E, James Wallace, charge of 1 count of simple assault. Whose case is this, Mr. McLean?
Yes, Your Honor.
All right, what do we have?
This will be time served with 8 hours anger management.
Okay. State?
Yes, Your Honor. So the state's offer is 12 months to serve 30 days, credit for time served, 15 days balance probated, 8 hours of anger management, no further contact, and a stay away from all martyr.
Okay. All right, is that your understanding, Mr. McLean?
Yes, Your Honor.
Okay. All right, Mr. Wallace, are you ready to take your plea?
Yes, ma'am.
All right, you stipulate, Mr. McLean?
We do.
Okay. All right, Mr. Wallace, raise your right hand for me.
Ma'am.
Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. Are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up or waiving your right to the presumption of innocence?
Yes, ma'am.
And do you understand that you're giving up or waiving your right to remain silent and not testify against yourself?
Yes, ma'am.
And do you understand that you're giving up or waiving your right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And has anyone promised you anything to plead guilty today?
No, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
And you are prepared to give up and waive these rights today, is that right?
Yes, ma'am.
And do you understand that if you're on probation, your probation could be affected by your guilty plea here today?
Yes, ma'am.
And again, I need to ask you, excuse me, do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
And again, how do you plead to the charge of simple assault?
Guilty, ma'am.
All right, thank you. I will accept your guilty plea so you understand the conditions. You're to take an 8-week anger management course, no further contact with the victims, and to stay away from all MARTA. So you will be doing other modes of transportation while you're on this 12-month probation. You understand that? You cannot get on MARTA.
Yes, ma'am.
Okay, they will know you and recognize you, and you will be right back in jail if you go to get on MARTA. Is that rail and bus?
Yes, Your Honor.
I'm sorry?
Yes, Your Honor.
Okay, so you can't ride the MARTA bus and you can't get on the MARTA train. So you're going to be taking Ubers, Lyfts, ride shares, or people will have to ride you around. You understand that?
Yes, ma'am.
Okay. All right. Good luck to you. I'll accept your plea.
Huh?
Okay.
Position 11, Ms. Johnson.
Okay. All right, this is 23 CR 004634Y, Ellen Johnson, charged with 1 count of contributing to the delinquency of a minor and reckless conduct from August 14, 2022. It says hold for announcement. What are we doing today?
Yes, Your Honor. Ms. Johnson would like to enter an Alford plea, so plead guilty under North Carolina v. Alford.
Okay. State, is that your understanding?
That is not our understanding, Your Honor. The state's offer was sent over contingent upon a guilty plea, not an Alford guilty plea. So that's our understanding.
Yeah, but Alford is in fact a guilty plea, Your Honor. It's still conviction and it's a still guilty conviction on a criminal record.
However, as everyone is aware, a guilty plea takes accountability for what it is that you have been accused of. So, Your Honor, again, the state's contention is that if this is going to be an Alford plea, that's not the terms of our agreement.
And with regards to that, Your Honor, if the state is not willing to accept an Alford plea, which is essentially providing that due to the circumstances, although she would maintain her not guilty status, based on the circumstances, she is taking the guilty plea so that she can, because her circumstances will not allow for that to happen. And if the state is not willing to accept that, Your Honor, we would like to go non-negotiated, but she was willing to accept the terms and conditions of the state's offer.
But just the Alford plea versus a regular plea?
Yes, Your Honor.
State?
1 second, Your Honor. All right, Your Honor. So are we going for the non-negotiated for the Alford?
Yes,
Okay.
I think so.
Yes, Your Honor.
Sure.
Okay. So this offense took place on August 14th of 2022, where officers met with the complainant Blaine Williams, who stated he was approached by the victim, juvenile named JJ, the initials of JJ, who reported that a man in the parking lot was touching her inappropriately. In response, he called 911. Officers then spoke to the mother, Missy Lane Johnson, who attempted to cancel the 911. She stated she had been out in the parking lot with several men drinking, and one of the men began to make advances towards her daughter. Johnson then sent her daughter up to the room inside of the hotel. Officers then spoke with the victim, who said that a man later identified as Roger Dwayne Hobbs approached her and offered her 1 ounce of marijuana. The victim wanted the marijuana, so she walked over to the parking lot near a dark area next to a white box truck. The suspect began to pull the victim close against his body and grabbed her waist and offered her money for sex. The victim did not want to have sex with the suspect. The Hobbs kept flashing a $100 bill, and the victim grabbed for the bill. Hobbs then walked away. Hobbs then turned around again and asked the victim to walk into the wood line with him. And in response, the victim kicked Hobbs in the groin. The defendant heard the victim yelling and she came to the victim. Hobbs admitted to offering the victim the $100 just to help out because he knew the family needed money. The defendant has 8 total cycles, but perhaps we should have heard from pretrial first, but there's a conviction for a possession of marijuana. She has arrest for a bad check, elder abuse, theft by shoplifting, and an FTA, Your Honor. So given the nature of this particular incident, that's why we wanted to ensure that this was a straight guilty plea. The state's offer for this particular case, Your Honor, is going to be 12 months to serve, 54 days, credit for time served 27 days, balance probated, 40 hours of community service, and supervised contact with the child, JJ, in a parenting course.
All right, so is this going to be an Alford plea or not? I'm just making sure I'm clear.
If Your Honor is inclined to accept the Alford plea, then over objection, that's perfectly fine. But per the state did not send their offer over with the contentions of an Alford plea.
All right, I will accept the Alford plea. And is that your understanding, Ms. Adams, to the terms and conditions?
Yes, it is, Your Honor.
Okay. All right. I will do that. And Ms. Johnson, are you ready to accept, ready to take your Alford plea?
Yes, ma'am. Yes,
Can
ma'am.
hear you? Okay. All right. Do you stipulate, Ms. Adams?
Stipulate.
Okay. All right. Raise your right hand for me, Ms. Johnson. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No, ma'am.
All right, and are you satisfied with the services and representation of your attorney?
Absolutely. Yes, ma'am.
Okay, and do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you're prepared and agree to waive these rights today, is that correct?
Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're on probation, your probation may be affected by a guilty plea here today?
Yes, ma'am.
And do you offer this Alford guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
And as to the charge of contributing to the delinquency of a minor, how do you plead?
Guilty.
And as to the charge of reckless conduct, how do you plead?
Guilty.
All right, I will accept your Alford guilty plea. And if there's nothing else, good luck to you.
Thank you.
Next, we
All
have
right.
position 22. Ms.
I'm sorry?
Position 22, Ms. Smith.
Oh. All right, this is 23 CR 004505J. Antoinette Smith, charged with 1 count of battery family violence. What do we have?
Yes, Your Honor. Ms. Smith would like to maintain her not guilty plea. However, we would be requesting, a signature bond in this case. With regards to her, does currently have a bond. That bond amount is, I believe it's $3,000 surety bond. Ms. Smith has been in jail for about 15 days. And with regards to this entire case, she was gainfully employed before being arrested. She since lost that job. That was a job at a place called Max over at the airport. But aside from that, Your Honor, she also does have a barber shop, so she is able to continue to make money. She has absolutely no desire to go back to the location or have any contact whatsoever with the complaining witness. She would just like a one-time, if the court so allows her to have a surety bond, Your Honor, she would just like a one-time escort so she can go gather her belongings, but she has no desire to have any more contact at all with the complaining witness.
You said she wishes to have a surety bond, or you mean a signature bond?
A signature bond, Your Honor. She currently has a surety bond.
All right, pre-trial, can I hear her history?
Yes, Your Honor. Defendant has 5 arrest cycles beginning in 2010. She has a misdemeanor conviction out of East Point for willful obstruction of law enforcement officer. Disposition is May 2012. She has another misdemeanor conviction for disorderly conduct. She took a NOLO plea on that December 2017 out of Baldwin Municipal Court. She has an arrest for criminal trespass, July of 2022 out of DeKalb County. No disposition is listed for that case. And her last arrest was December of 2022 for a theft by taking. And there is no disposition listed for that case also. And that was out of Atlanta. Nothing to add, Your Honor.
All right.
Oh, wait, I'm sorry. Hold up. Hold up. Let's see. She does have, 5 arrests out of Florida also. Her last arrest in Florida was March of 2016, and that was for aggravated battery with a deadly weapon. Maybe it's not giving me the disposition, just says filed. It gives me a file date and it says charge resulted from arrest. So I'm not exactly sure what the disposition of that case was.
They dropped the charges.
Okay. And she has 1 violation of probation and a misdemeanor battery from 2013. Nothing to add.
All right, thank you. State.
Yes, Your Honor. If I could just have 1 brief second to see.
Okay.
All right, Your Honor. So first and foremost, this incident took place on 7/18, where officers were called to 1188 Joseph Boone Boulevard, and which Miss Rosina Casolo, which at the time was the defendant's girlfriend, stated that the defendant assaulted her, causing her to go to the hospital. When she came home, she was watching a movie with her son, and the defendant came into the room intoxicated and began a verbal dispute with her. The defendant then grabbed her face, digging her nails into her skin and punching her in the face multiple times. The victim then stated she was already injured from the previous day and on medication, so she could not fight back. The victim said that although Ms. Smith left, she believed that Ms. Smith would return. After leaving the location, officers received a call from dispatch that Ms. Smith had in fact returned. Since the officer was still in the area, he returned to the location and took the defendant in custody. As Your Honor is aware, this bond was given on 7/20 in front of Judge Morrow. The state will contend that there has not been any changing circumstances since Judge Morrow gave her the $3,000 bond. If we go back to this defendant's history, there was an arrest for a criminal trespass in December 2022. And then there was another arrest in 2022. She picked up this charge in 2023, which shows that this defendant is likely to reoffend if if given bond, Your Honor. There is a violation of probation, which states that she does not obey by the laws and the enforcements of things that are given to her. She's also a multi-state offender, Your Honor. Although that was back in 2016, it shows that the defendant has traveled from Florida to the great state of Georgia and is still committed.
Great state. What's great
And
about
it's
that?
still,
Hold on. You're not to interrupt, Ms. Smith.
thank you. And it's
Go
still
ahead.
committing crimes, Your Honor. Alleged crimes at this particular point, Your Honor. So the state's contention would be that we keep the $3,000 good bond, Your Honor, as again the defendant is alleged to have attacked the victim one day and then came back the next day and attacked and then left and then came back. The defendant picked up additional charges in 22. This happened in 23. So that is the grounds for the state's recommendation, Your Honor.
If I may, Your Honor, with regards to the change in circumstance, state contends that there has been no change in circumstance. However, Ms. Smith has been incarcerated for the past 15 days, and I think that that is a huge change in circumstance, considering the fact that she has had no contact with this complaining witness. In addition to that, again, I'd like to restate the fact that she wants absolutely nothing to do with her. She doesn't want to be in her presence. She does not want to be around her. The state has made many allegations, but they are just that. And that's the reason why Ms. Smith maintains her not guilty plea, because she would like to have her day in court. Today is not the day to have a trial. It's literally the day to talk about the possibility of bond. And with regards to that, Ms. Smith does have her own side of the story, and she would like that to come out at the appropriate time. With regards to bond, Your Honor, despite the fact that it's been more than 7 years since Ms. Smith had any offenses in another state, and she is trying to turn her life around, Your Honor, which is why she had 3 jobs. There are some other issues that are going on between her and Ms. Smith, which is why she would like to, with Ms. Smith and the complaining witness, which is why she would like to get away from her and get as far away from her as she can. And but at the same time, she would like to still have maintain her life. And so with that, Your Honor, that's the reason why we are requesting that she get a signature bond so that she can be able to move forward with her life, go ahead and continue to fight this case, and fight for vindication of the charges that have been brought up against her here, and continue to try to be a better member of society.
And so she has somewhere else, I guess, as far as not having any contact. This address on Joseph Boone Boulevard, whose address or what is that?
That's the complaining witness address, Your Honor. She has been living there, renting a room from that location, Your Honor. And so she is perfectly fine with a police escort gathering all of her belongings, including her dog. And
my barbershop.
Yep, and her barbershop, because it is located in the back of that house, getting all of her belongings, including the equipment for her barbershop, and removing herself completely and totally from that space.
Yeah.
So the barbershop was at this location.
But no, I will move. I can let it go. Cause I just started my page up. I just relocate the address to a pass split. That ain't nothing. I just got to get my chairs and all my lawn equipment up out of there. That's it. And my dog. She could really have a dog, honestly.
Your Honor, the state now has some new concerns about ties to the community. The barbershop was one of the things that defense counsel mentioned, that she is a business owner and that she makes money from this particular barbershop. It seems like this is a more so of an in-home kind of a thing that is extremely mobile, as the defendant just stated. With regards to the dog, any property that's in the home should remain in the home unless there's proof that she truly owns that property. We don't want her to.
I got proof that I own it.
If you cannot interrupt me,
I've asked you once not to interrupt.
If we can get the one thing we don't want to happen is for her and the sheriff to show up. And then there's another situation about an animal, Your Honor. So
I don't want it.
So with regard to Ms. Smith, please, with regards to Ms. Smith's property, considering the fact that this is her residence as well, she obviously is gonna have property there. And with regards to the dog, she's willing to relinquish the dog just to avoid any further issues with this complaining witness. With regards to the mobility of her barbershop, that has nothing to do with the fact that she has had intentions on continuing to keep her roots here in Georgia. And where did the judge go?
she turned off her camera. She's still on though.
Okay, that has nothing to do with the fact that she has every intention on continuing to build her roots right here in the state of Georgia and continuing to grow her business. She would like to do that from a place where she doesn't have the types of stressors and issues that she's had at that location, which is why she would like to remove herself from that situation and space totally.
Right, who set the original bond and when?
That was Judge Morrow set the original bond, Your Honor, and he set that original bond back on July 20th of 2023.
Okay. It's a low bond in the sense of 3,000 surety, even with the history that we have. And so she's not been able.
Nobody
to
knows
bond.
I'm here but her.
Ms. Smith, please stop talking. I'm sorry, Your Honor.
Well, you know, I'll be real frank about it. I continue to tell Ms. Smith not to interrupt, and Ms. Smith continues to interrupt. I'm detecting a little bit of an attitude there. And I understand she may be anxious and want to get out of jail. Most people do. But respect for the court is very important. Respect for the process is very important. And I'm not sensing a lot of respect for the court or the process by Ms. Smith. And so, you know, one of the items that goes with respect is following instructions and directions and not being rude. And so when you interrupt someone, especially the prosecutors when they're talking, don't take light of that. Don't think that defendants, as anxious as they may be, there's been an incident, but you still have to respect the people and the process. And I hope that Ms. Smith will do that. And I have great regard for Judge Morrow, who heard this case originally and heard the facts and set a very reasonable $3,000 bond. And so I'm not going to change it to a signature bond, but I will reduce it to a $2,000 surety bond to go through a bonding company. But I will reduce it, Mr. Jordan, to a $2,000 surety bond.
Thank you, Your Honor.
All right, you're welcome. Next case.
Position 10, Mr. Gallant.
This is 23 CR 004535C, Larry Gillette, charged at 1 count of simple battery and 1 count of disorderly conduct. Let's see. And this is going to be a plea, a negotiated plea.
Yes, Your Honor.
All right, state.
Sorry, I was on mute. Yes, Your Honor. So the state's understanding of the plea is going to be 12 months to serve 28 days, credit for time served 14 days, balance probated, 6 weeks of anger management, no further contact with Tashelle Lowe, and that's TYESHEHALLOWE, and stay away from Marta.
Okay, and that's all MARTA bus and rail, right?
Yes, Your Honor.
I say that sometime because people think, you know, they can get on the bus, but not the train or vice versa. So that's why I want to be clear with that. When we say all MARTA, we mean both, so that people don't get confused by that.
And
All right.
My
Go ahead,
apologies.
Mr. Jodis.
My apologies, Your Honor. It's hard to, I didn't mean to interrupt.
It's
this
okay.
Yes, Your Honor. So while it is our intention for this to be a negotiated plea, instead of the stay away from all MARTA, we would just ask it to be worded as comply with any active MARTA suspensions. Mr. Galat is residentially challenged and he does rely on MARTA to get around town. This is a balanced probated sentence. So he's clear that he has to do the anger management and all of that, but we don't want this to restrict him from getting around the city, finding stable housing, finding a job. I've provided him with resources, and he's clear that there is a current active MARTA suspension and has the number to check in on that. But we don't want this to hinder him once that suspension is lifted.
I guess the problem is, and I'll hear the facts from the state, if he committed a battery disorderly on MARTA, he's a danger to the citizens who are riding MARTA. And if he were to be restricted and there's already a suspension in place and he's got to do the 6-week anger management, certainly the suspension would go through continuing with the or completing the conditions. The problem I have is that, you know, we don't want to put citizens in danger by him getting back on MARTA too soon and not realize that we're not going to accept that kind of conduct. So let me hear a little bit of the facts, or do we even know when the current suspension expires?
I can look up when the current suspension expires, Your Honor, but you are exactly right. Officers were flagged down by MARTA, who advised that a heavyset male was throwing things at people upstairs at the north end of the station. Officers observed the defendant attempting to throw an object at an unknown person. And then a MARTA employee approached the officer and said that the defendant had spat on her intentionally. So yes, this defendant is clearly doing unprovoked things to members of the society. So the state's contention would be to protect the members of society. I will look up the active suspension, see if it's mentioned right now.
Okay. Let's see what that is.
I'm sorry, Your Honor, I'm having problems with Odyssey. 1 second.
Okay.
There. Your Honor, I do not believe that there are any active suspensions, hence why he probably did not, why he doesn't have the criminal trespass charge. So I'm not seeing one in the notes either.
You have anything on that, Mr. Jodis?
I don't, Your Honor. If we don't have that, then I understand, but this incident just occurred at the Civic Center MARTA station, so I'd ask the stay away to be limited to that location.
And again, Your Honor, he was throwing things at random people. So whether it was the Civic Center, next it could be 5 Point, next it could be DeKalb, Lindbergh, who knows?
Right, we don't know. That's why we're dealing with an incident that allegedly already happened. We're not making presumptions about what will happen in the future.
So this happened on July 21st, 2023. I am concerned about his actions are pretty serious, and I certainly don't want to put anyone in jeopardy. I would at least state, and if he's going to take this plea, that he stay off of all MARTA until he completes the 6-week anger management at best. But I'm inclined, as I have in other cases, they just have to get around other ways. These days, there are other ways to get around. It may not be as efficient, but I want to make sure, again, the citizens are safe and that he's learned his lesson and he's not going to do whatever he was doing before, which sounds pretty serious, throwing things at people that could have hurt several people. So I'm not excited about the facts or letting him get back on MARTA too quickly. And then we're back here again. This hasn't even been that long ago. So I'm sure if there's a suspension in place, it's probably at least 6 months to a year. But the fact that you all can't find it bothers me. So I have to make sure that I protect the citizens with this plea.
Thank you, Your Honor. And I understand that position. I think it's fair. Mr. Galat is clear that the allegations are to be taken seriously. And I believe that with the 6 weeks of anger management, any future issues can be avoided.
All right, State, I know what you're probably going to say. I will restrict him if we can't find an active suspension. Before he can get back on MARTA. Usually we do it through the 12 months of the probation, correct?
Yes, Your Honor.
And because of the facts, Mr. Dotis, I'm going to require him to stay off for the 12 months because that's probably what MARTA has said if they haven't banned him totally. But I will at least say that he will stay off MARTA, all MARTA for 12 months. That will be part of the plea terms. Let's have it for the 12 months.
And then, Your Honor, I know we just discussed this, but still have to request if we could terminate probation upon the completion of the 6 weeks of anger management. And as I stated, Mr. Galat does not have stable housing, so we would ask the court to waive all of his probation fees.
Cannot waive all of his probation fees. I will waive 6 months of the probation fees. But I'm not for sure about him coming off probation or just going non-reporting. I wouldn't suspend it and he not have to report it all after the 6 weeks anger management. I'll waive 6 months of the fees, but he after he completes it, he can go non-reporting, but I'm not going to dismiss his probation.
Understood. And then just to clarify, I'm not sure where we landed on it, but was it stay away all MARTA until completion of the anger management? Or did?
No, I retracted from that and
Okay.
just said that the terms of the probation, stay away from MARTA for 12 months, which would be the probation term.
Understood, Your Honor.
Okay. All right, so are we clear?
Yes, Your Honor, we're clear. This is going to be a negotiated plea.
All right, is it Galat? Yes. Oh, ask him to unmute you. Okay. Yes, sorry, I don't want to mispronounce your last name. Is it Mr. Galat?
Yes, ma'am.
All right, you ready to take your plea?
Yes, ma'am.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No, ma'am.
All right, are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
And that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever is preferred?
Yes, ma'am.
And has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be affected by your guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
And so as to the charge of simple battery, how do you plead?
Guilty.
As to the charge of disorderly conduct, how do you plead?
Guilty.
All right, so you've got 12 months to serve, 28 days, credit for 14 days, balance probated to take a 6-week anger management course, no further contact with Tyshell Lowe, and you're to stay away from all MARTA bus and rail for the 12 months of your probation. I will waive 6 months of your probation fees. As a courtesy, I will allow you to go non-reporting once you have completed the 6 weeks of anger management, but you are to stay off and away from all MARTA for 12 months. All right?
Yes, ma'am.
You can do that, then you can start over after the 12 months, and hopefully we will not see you again regarding any type of infractions, okay?
Yes, ma'am.
All right, good luck to you.
Thank you.
Your Honor, we're gonna go to position number 5 in courtroom 2. That's gonna be Mr. Dontre Bradley.
All right. This is 22 CR 0005555A, charge of 1 count of criminal trespass. State?
Yes, Your Honor. So the state's offer is 12 months to serve 18 days, credit for time served 9 days, balance suspended, and then stay away from Wells Fargo, which is 6300 Roswell Road.
All right. Mr. Dotis, is that your understanding?
Yes, Your Honor, that's our understanding, and we do stipulate to the factual basis, venue, and ID.
All right. Mr. Bradley, are you ready to take your plea?
Yes, ma'am.
All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. First question I have, are you under the influence of any unprescribed medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
Has anyone promised anything to plead guilty?
No, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
You understand that if you're on probation, your probation could be affected by your guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
As to the charge of criminal trespass, how do you plead?
Guilty.
All right, and so you've heard the terms, and you are to stay away from the Wells Fargo on Roswell Road. Is that correct?
Yes, ma'am.
All right, you do that, I won't see you again, okay?
Yes, ma'am.
All right, good luck to you.
Thank you.
Position 4, Mr. Bloxton.
This is 23 CR 004530A. Mr. Bloxton, charged with 1 count of simple assault. Is this going to be a negotiated plea?
Your Honor, I believe this will be a negotiated plea. I did write on my announcements to confirm jail time. It looks like based on the offer, with no additional jail time, but he was given credit for 16 days. As of today, Mr. Bloxton has 14 days. So we just asked the offer to be written as served 28 days, credit for time served 14 days. Spirit of the offer is the same. He's clear on all of the other conditions.
Okay. State?
That's fine, Your Honor. That was the spirit of the offer was a time serves.
Okay.
So the state's offer is going to be 12 months to serve 28 days, credit for time served 14 days, balance probated with the 6-week anger management, no further contact with Kaylee Felton, and stay away. I'm going to get the address in 1 second.
Okay.
It's going to be 10777 Alpharetta Highway in Roswell.
Right, is that your understanding, Mr. Dotis?
That's our understanding, and we do stipulate to the 3 elements for the purpose of this plea. I clarified this with Mr. Bloxton yesterday. He is clear that that stay away address is for the Krispy Kreme, and that he does need to steer clear of that business.
We have Popeyes.
Popeyes, I'm sorry.
That's what's on your mind, Mr. Dotis.
My apologies, Your Honor. Mr. Bloxton last worked at Krispy Kreme. I got my wires crossed.
That's okay. All right, Mr. Bloxton, are you ready to take your plea? Ask them to unmute you. Okay, you ready to take your plea, Mr. Bloxton?
Yes, ma'am.
All right, so raise your right hand for me. All right, do you affirm that the testimony you're about to give is the truth, nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down for me. All right, are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
You're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
Has anyone told you that you will receive anything for pleading guilty?
No, ma'am.
Have they promised you a lesser sentence for pleading guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be affected by the guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, I do.
All right. As to the charge of simple assault, how do you plead?
Guilty.
All right. I will accept your guilty plea. Again, you've got to stay away from the Popeyes, no further contact with Kaylee Felton, and you to take a 6-week anger management course. And I will accept that guilty plea with 28 days, credit for time served 14. All right. Anything else, counsel?
Your Honor, we would request Mr. Bloxton's probation to go non-reporting upon completion of the anger management. As stated previously, he did last work at a Krispy Kreme, and I'm hoping he can return so that I can pick up a dozen glazed. But not clear.
Right.
We're not clear if that job is waiting for him. So we would request the court to waive a few months of his probation, to help him land on his feet.
All right. To help him get back on his feet, we're going to waive 3 months of his probation fees. And Mr. Bloxton and Mr. Dotis comes in. Treat him fair, okay? All right. Good. Yes. Good luck to you.
All right, thank you.
All right. You're welcome.
Position 34 and 35. Mr. Witness.
And that's going to be Attorney McLean. He's currently on the phone, I believe, with the client. You may be wrapping up. We could hold.
Okay. Let's see if he's
Judge, on that last case, did you say non-reporting or just to waive the 3 months?
I did the waiver for 3 months. I don't know, State, did I say non-reporting or not? I don't think I did.
You didn't.
Okay, thank you.
Also, while we have a break, Mr. Jordan did say that Ms. Smith had not been arraigned.
Okay.
Yes, Your Honor, I have just drafted a waiver of arraignment, and I'm gonna go ahead and make sure that that gets taken care of today.
Okay, great.
And Your Honor, it was for position 4. We would request non-reporting, so my apologies if I missed it. I thought that was an affirmative, but if we need to readdress, we can.
All right, Mr. Jordan, I'm sorry. I will allow him to go non-reporting after he's completed he was 6-week anger management, right?
Yes, Your Honor.
Okay, I will allow him to go non-reporting.
Thank you for catching that, Mr. Jordan. Are you ready on 34? Sure. Robert Williams, yes, sure.
Your Honor.
Yeah.
Position, what was that? 23?
23.
Yes, I guess Ms. McLean have an announcement for that one too.
Yeah,
Okay.
I spoke to him and got his authorization to waive the arraignment, Your Honor. That's fine. We would like to go ahead and reset the bond argument for 1 week, 7 days.
All right.
Yana, I was also informed by Mr. Walker from our office that the charges on the calendar are incorrect. It should be 1 count of battery family violence and a 2nd count of simple battery family violence. I'm not sure if that's an internal thing that we could probably talk about later in order to keep it moving, but I may not be on this particular calendar 1 week from today, but
Right. Mr. Jordan, he's looking at that, I think.
So that's correct. The accusation for count 1 is battery family violence. And the accusation for count 2 is simple battery. So I'm not sure how these printed out on the calendar like this. But I'll make the adjustment.
Okay.
And you said it reset 1 week?
Yes, that's what he said. He wanted a 1 week reset.
Last night.
All right, you ready, Mr. McLean?
You're on mute, Mr. McLean.
Thank you. We'd like to do a bond argument next week, possibly, so I'd like to do a reset, and I'll let the court know if we need to cancel that. But as of right now, we plan to make a bond argument on these charges unless it clearly is moved to us. We'll change that later. And we'll just waive arraignment for today, plead not guilty.
All right, on Mr. Smith, correct?
Yes, Your Honor.
All right, so we're resetting him to when, Mr. Jordan?
August the 10th.
Okay.
And Your Honor, the state just wants to perfect the record and let it know that the state was definitely prepared today to go forth with a bond argument on Mr. Smith. And with regards to like changed circumstances and Mr. Smith spending more time in the jail without a bond, we just want the record to show that it was not because of the state's request for a continuance.
All right, that is accepted. And so, Mr. McLean, you want to wait to make that bond argument on the 10th, is that correct?
Correct, Your Honor.
Okay, all right, we'll do that. And I believe the record should be clear that that was a defense counsel's request. I see a note. Okay, on 17. All right, who do we have next? I'm sorry.
I was just gonna say on position 17, Ms. McLeod had to go to another hearing.
Okay.
But he wanted that case reset for a jail jury. And she said it's already been arraigned.
Okay, good, thank you.
Position 34 and 35, Mr. Williams.
Okay. This is 23 CR 004520F. Robert Williams charged with 1 count of willful obstruction against a law enforcement officer. That's July 20th, 2023. And 35 is 23 CR 004524F. Charged with 1 count of criminal trespass, count of simple battery against a police officer, police dog, or correction detention officer, and 3rd charge of pedestrian in the roadway, July 19th, 2023. And what are we doing with both of these cases? Are these pleas or no? Yes, negotiated pleas.
Both are negotiated pleas, Your Honor. Number 34 will be a suspended, time served balance suspended type of plea. But probation is involved, and we'll do a contact sheet for JCS on number 35, which does involve some probation.
Okay. I have it, state.
Yes, Your Honor. So the case ending in 4520F, the state's recommendation is going to be 12 months time served, 15 days, balance suspended, no further violations of Georgia law. And then the case ending in 4524F, the state's offer is going to be 12 months to serve, 30 days, credit for time served, 15 days, balance probated with a 6-week anger management and a stay away from First Drive, I believe.
Stay away from.
Stay away from 311 First Drive.
Okay.
That would be spelled F-E-R-S-T.
F-E-R-S-T, thank you.
Correct, it's a proper name.
All right. And then that's for 35, but 34 is just no further violations. Okay. All right. Those are the understandings. I will take both pleas at the same time. Mr. Williams, are you ready to plead guilty?
Yes, Your Honor.
All right. Mr. McLean, you so stipulate?
We do stipulate, Your Honor. Thank you.
All right. Mr. Williams, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
I do.
All right. And tell me this, are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No.
Are you satisfied with the services and representation of your attorney?
Yes, Your Honor.
And do you understand that by pleading guilty to, in both of these cases, you are giving up or waiving your right to the presumption of innocence?
Yes, Your Honor.
Giving up and waiving the right to remain silent and not testify against yourself?
Yes.
But you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And has anyone told you that you receive a lesser sentence for pleading guilty?
I thought I was supposed to receive 6 hours of anger management.
The court is asking basically, are you promised or guaranteed anything?
No, I'm not. I wasn't.
But it is 6 weeks, not 6 hours. I will tell you that. It's 6 weeks.
Well, Your Honor, the 6 hours of anger management typically can be done once a week for an hour. It's also possible to get online and do 4 hours on a Saturday morning and 2 hours on the next Saturday morning.
Okay.
Okay. It's my understanding, I guess, in position 35, that 6 weeks, however it is broken up. But it is a total of 6 weeks. Is that correct?
Well, Your Honor, we use 6 weeks as slang. The main point is it needs to be 6 hours of instruction.
Is that your understanding, ASG Jones?
So our understanding is that it's 6 weeks. He at minimum, he can take 1 hour every week, which is what the state's recommendation is.
Well, we've never gotten into the detail of educational standards. The instruction is the instruction. So I would think that doing it in clumps would be fine.
Right. However you do that, Mr. Williams, we will not scrutinize it, okay?
Okay, yes,
Just as long as you can complete the course, okay?
Okay, I will.
All right. And again, do you understand that if you're currently on probation, that could be affected by your guilty plea today?
Yes, ma'am.
All right. And you offer the guilty plea on both cases, one ending in 524F and the other ending in 520F, that you are pleading to both cases freely and voluntarily with the full understanding of the charges against you. Is that correct?
Yes.
All right. I will accept your guilty plea to both cases. And you have your understanding and your stay away on the second case from that first FERST drive as well. Okay.
Yes, Your Honor.
All right. Good luck to you.
Thank you, ma'am.
Uh-huh.
Next, Your Honor, we're going to go to position 21, Mr. Sims.
Okay. This is 23 CR 004635C. Mario Sims, charged at 1 count of theft by shoplifting. This is I don't know. Let me hear the announcement on this case.
Yes, Your Honor. After speaking with Mr. Sims, he is fine with the recommended offer from the state, but he would request to enter a no-low plea today.
State?
Yes, Your Honor, the state would object. I don't know if Your Honor wants to hear this defendant's criminal history from myself or from pretrial services. However, I can give it. There's a probation violation in 2023, a DUI conviction in 2022, a probation violation from 2018, a terroristic threats from 2019, a FTA in 2015, a probation violation in 2015, another terroristic threats in 2014, a possession of marijuana 2012, a forgery in 2007, probation violation in 2006, ag assault 2001, shoplifting in 1995, FTA in 2022, these are arrests. So FTA arrest in 2022, a criminal trespass in 2022, a FTA in 2019, a shoplifting arrest in 2016, and a DUI arrest in 2015. This defendant has a total of 21 previous cycles. The facts here is that officers were called to Walmart for a report of shoplifting. Upon arrivals, officers spoke to the loss prevention officer, who stated that the suspect later identified it as the defendant. Mr. Sims was observed exiting the store without paying for the merchandise he received at electronics. The total value of the electronics was $318.41. The officer took Mr. Smith into custody, and he was criminally trespassed from the premise. Your Honor, given this defendant's 21 cycles that I just went through, the state would be opposed to a nolo contendere. The state's offer on this case is 12 months to serve, 35 days, credit for time served, 35 days, balance probated, a stay away from the Walmart, which is 4735 State Route 138, Union City, and a anti-theft class, as the items were recovered upon his arrest. So there's
no restitution.
Correct.
And I don't know, Mr. Dotis, is he qualified to enter a NOLO plea? Has he not pled NOLO in the last 5 years with all that he has?
My understanding, and I didn't hear otherwise, that he has not entered a NOLO plea in the last 5 years.
I see ASG Jones might be checking.
I am, Your Honor. It does not look like he's entered a NOLO plea, Your Honor.
Okay, we're not finding it. I guess I can accept a NOLO plea then.
Thank you, Your Honor.
Okay. All right, Mr. Sims, are you ready to take your plea?
Yes, Your Honor.
All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, and put your hand down. Are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving your right to the presumption of innocence?
Is that the same as NOLO?
Well, by pleading guilty NOLO, but it's still a NOLO plea. Yes, I will correct the language a little bit, but you are giving up your rights to the presumption of innocence even with the NOLO plea.
Yes, ma'am, that's correct. But I want you to know that.
I'm sorry?
Nothing, Your Honor. If you have a question, Mr. Sims, I'm happy to talk to you outside of court.
Okay. And that you are giving up and waiving your rights today with this NOLO plea to remain silent and not testify against yourself.
Yes, ma'am.
You're giving up your right to trial by judge or jury, whichever you prefer.
Yes, ma'am.
Has anyone told you receive a lesser sentence for your NOLO guilty plea?
No, ma'am.
Has anyone promised you anything to plead NOLO? And do you understand if you're currently on probation, your probation may be affected by a NOLO plea?
Yes, ma'am.
And do you offer this NOLO plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
And as to the charge of theft by shoplifting, how do you plead?
No low.
Okay. Okay. All right, I will accept that. You have 12 months to serve, 35 days. Credit for time served at 35. You are to stay away from the Walmart in Union City on State Route 138 and to take an anti-theft course. You understand that?
Yes, ma'am.
All right, so please do not go back to the Walmart or else you will be right back here, okay?
Yes, ma'am.
All right, good luck to you.
And
Thank you.
Your Honor, we would request the court to waive a few months of Mr. Sims' probation fee so he can get back on his feet. He's currently a handyman, and he will need to build back up his business as he has been in custody the past 35 days. We would also ask it to probation to go non-reporting upon completion of all conditions. I provided him with probation's phone number and contact information, as well as a link to a theft class that we recommend. So I'm confident that he'll swiftly complete everything that the court has asked of him.
All right, I will not be able to waive any of his fees, but I will let him go non-reporting once he's completed the anti-theft course.
Thank you, Your Honor.
Your Honor, and we just want to reflect for the record that the state did object to his NOLO plea given his extensive history, and the state will also object to the non-reporting given his that same his the amount of FTAs and the probation violations he's had. So
Okay, thank you. Who do we have next?
I don't have a position number, but his name is Jamel King.
Okay.
Hey Duffy, can we do position 7 and 8 real quick?
Yeah.
Thank you.
What's King position number?
He is King. I don't have a king on mine.
I believe he's an add-on, Your Honor.
Mr. King is on the probation revocation calendar.
He's on probation revocation, not the regular calendar. Okay.
Okay.
And who are we going to do now?
Your Honor, position 7, position 8, Elijah Crawford.
7 and 8. All right. 22 CR 004596F and 23 FTA as well. Mr. Elijah Crawford charged with 1 count of theft by shoplifting. State?
Yes, Your Honor, the state's recommendation is going to be 12 months balance probated with the anti-theft class. Stay away from Walmart 6, which is 6149 Old National Highway.
All right. Is that your understanding, Mr. Dotis?
That's our understanding of the offer, and we do stipulate to the factual basis, venue, and ID for the purpose of this plea.
All right. Mr. Crawford, you ready to take your plea?
Yes, Your Honor.
All right. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. Are you presently under the influence of any unprescribed medication, drugs, or alcohol? I'm sorry?
No, ma'am.
Okay. Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you're pleading guilty, you're giving up the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer? You're giving up that right to trial by judge or jury, correct?
Yes, ma'am.
All right. Has anyone told you that you receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
You understand that if you're currently on probation, it could be affected by your guilty plea today.
No.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
I'm sorry?
Yes, ma'am.
Oh, okay. All right. And so again, as to the charge of theft by shoplifting, how do you plead?
Guilty.
Thank you. All right. So you have to take that theft course and stay away from the Walmart or Old National. Can you do that?
Yes, ma'am.
All right. I will accept your guilty plea. Good luck to you.
Thank you.
And Your Honor, we would ask that probation switch to non-reporting status upon completion of the theft class.
Didn't hear any history state.
1 second, Your Honor. No history, Your Honor.
Okay.
But he did
All right.
FTA on this particular case on April 17th of 2023.
All right. I will allow him to go non-reporting after he's completed the theft course.
Thank you, Your Honor.
All right. Thank you.
Ms. Missy, what was the sentence on this case?
12 months, balance probated, theft course, and to stay away from Walmart.
So they want him to serve the full 12 months?
Oh, credit for, yeah, I was getting ready to say, hold on.
Credit for time served. Your
Yes.
Honor. Sorry about
We
that.
all left that out. Sorry about that. Credit for time served. I don't know how many days because there's none stated on the calendar.
I believe it's, Your Honor, my apologies, and I filled out the plea paper thinking I saw time served, so that's my apologies. I believe he has credit for 10 days on the FTA, but if I could have a moment to confirm.
Okay,
That is correct, Your Honor. It is 10 days.
10 days. All right, thank you. Hey, Deputy Falk, how are you?
Doing well, Your Honor. Thank you.
Good. I didn't know you were with us to help Mr. Jones today.
Just popped in toward the end.
Popped in, okay.
If I may make a request, Your Honor, and
yes,
my video is having some trouble starting, so it just may take a moment. Miss
Okay.
Ryan, who's with us from municipal court, she can be released if with Your Honor's consent. She's an attorney here. She was just subbing in for us while we were in training, but I'm here now with Mr. Jones.
Okay, great. Thank you. Appreciate the help here, Miss Ryan. And you said Miss Ryan was from municipal court?
I believe she's from City of Atlanta Court. Yes.
Oh, okay. Miss Ryan, can you hear us? Or she may already be gone.
Yeah. Okay.
She just private messaged me and told me her mic isn't working.
Oh, okay.
Well,
Who do
Your
we have
Honor,
in-
we can go forward. I just wanted to release her in case you wanted to go ahead and leave.
Yes, that's fine. Who do we have in 4 North? Or is that where we're going?
Position 28.
28?
Yes, ma'am.
Okay. That is is it Threet?
Yes, ma'am.
Okay. That's 23 CR 004521B. Charge at 1 count of PI.
Your Honor, what position is this? My apologies.
28, Mr. George Threet.
If we could hold, Attorney McLean is on the phone. That's his position.
Okay, I hear him.
Your Honor, so can we go to position 12, Mr. Charles Knox, position 12.
Okay. This is 23 CR 004609J, Charles Knox. Charge at 1 count of criminal trespass. State.
Yes, Your Honor. So the state's recommendation is going to be 12 months to serve, 20 days credit for time served, 10 days, balance suspended, and a stay away from. One second, Your Honor.
Okay.
The stay away is going to be 7410 Oakley Road, Union City.
Okay. All right, that's your understanding, Mr. Dotis.
This is actually Samantha Adams, Your Honor.
Oh, I'm sorry. I'm
It's
sorry,
okay.
Miss Adams. I didn't even look up. I'm sorry.
Didn't
Yes,
see
ma'am.
us to play our little game of musical chairs.
I see.
Yes, Your Honor, that is the defense's understanding. The only thing I don't think I provided to the state is that this will be a NOLO plea.
All right, state.
1 second, Your Honor.
Okay.
This is position number 12, correct?
Yes.
Correct, Charles Knox.
It looks like his last conviction was in 2016. However, Your Honor, I'm sorry, I misspoke. He has a simple battery family violence conviction in 2016, a forgery in 2017, a hijacking a motor vehicle conviction in 2019, no valid driver's license in 2019, a robbery conviction with 5 years of confinement, 5 years of probation in 2019, a theft by receiving in 2023. He has been arrested for manufacturing drugs, resisting arrest, simple battery, FTA, possession of cannabis, giving a false name, armed robbery, ag assault, possession of a firearm, then the commission of a certain felony, and a criminal trespass. Based off of that, we would ask that we would object to a NOLO plea. I will check his criminal history as well to see if he has used it in the last.
For the record, Your Honor, the 5-year rule with regards to a NOLO plea only applies to traffic offenses. And this is not a traffic offense, so it would be up to the court to accept whether or not it would be up to the court to decide whether or not they'll accept a NOLO plea.
I'm going to deny the NOLO plea.
Right, then I'll change his plea to guilty, Your Honor.
I'm sorry.
He'll change his plea to guilty.
Okay. All right. You're ready to take your guilty plea, Mr. Knox?
Yes, ma'am.
All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, and put your hand down. Are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving your right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving your right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you also are giving up and waiving your right to remain silent and not testify against yourself?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised anything to plead guilty?
No, ma'am.
And you understand that if you're on probation, your probation could be affected by a guilty plea?
Yes, ma'am.
And you are pleading guilty to this criminal trespass, and you're doing so freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
All right. I will accept your guilty plea, 12 months to serve 20 days, credit for time served at 10 days, balance suspended, and to stay away from 7410 Oakland Road in Union City.
Okay.
All right, I accept your plea. Good luck to you.
All right, thank you.
Uh-huh.
Position 28.
Okay. All right, is that Mr. Threet?
Yes, Your Honor, it is.
Okay. Again, the charge, I will just say it as PI. And state, you may proceed.
Is this a negotiated plea, Your Honor?
Yes.
Oh,
Okay.
let me ask. Okay, I'm sorry.
So
Yes,
this-
it's gonna be involving 15 extra days as I count it.
Yes, Your Honor. So the state's offer is going to be 12 months to serve 60 days, credit for time served 15 days, balance probated, SDET, no further contact with the victim. I can provide her name and to stay away from all martyr. The victim's name is Sarah Nichols.
Okay.
Your Honor, we've discussed that thoroughly and he understands the terms and conditions and he stipulates to the jurisdiction that is venue, the factual basis and the ID.
All right.
Or to accept his negotiated plea of guilty.
Okay. All right, Mr. Threet, you ready to take your plea now?
Yeah.
All right, raise your right hand for me. You affirm the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. Are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am, I am.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
You're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
You're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And has anyone told you you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised anything to plead guilty?
No, ma'am.
And you understand that if you're on probation, your probation could be affected by a guilty plea today?
Yes, ma'am.
All right. And you offer this guilty plea freely and voluntarily with the full understanding of the charge against you. Is that correct?
Yes, ma'am.
All right. I will accept your guilty plea. And you understand the terms. You have to do a SDET and no further contact with Sarah Nichols and to stay away from Marta. Is that bus and rail for the 12 months of probation?
That is, Your Honor.
Okay. All right. And so you understand those conditions?
Yes, ma'am, I do.
Okay. All right. I will accept your plea and good luck to you.
Thank you, ma'am.
Uh-huh.
Your Honor, I do have a violation of probation hearing with Mr. Michael Posey today. I noticed that Mr. Garland Hogan has just gotten on Zoom with us. He's with PAD, PAD. I wondered if we could go to that.
I'm sure probation won't argue with you, but Mr. Jones might, but we'll be flexible. All right, and on the probation revocation, that's Mr. Posey, you stated?
That's correct, P-O-S-E-Y, Michael.
Okay, all right. And I have that as 23 CR 001869C, and then the violation as well. Probation, Ms. Harris?
Good morning, Your Honor. How you doing?
Good morning, how are you?
I'm doing great.
Good.
I'm ready when you are, Your Honor.
All right, we have Mr. Posey, FTA'd on June 16, 2023. What's the recommendation of probation?
Yes, Your Honor. He was sentenced on April the 11th of this year to 12 months to complete a drug and alcohol evaluation. As of today, he has not reported to our office. He has 8 months, 1 day remaining, and probation recommendation is to revoke.
All right, Mr. McLean.
Your Honor, Mr. Hogan tells me that about 30 days ago, PAD was going to pick him up from ACDC to put him in a program, and this hold popped up. Your Honor, better than revoking 8 months of his time would be to have him go to that PAD program. Mr. Hogan could explain its elements if desired. Mr. Hogan was saying, since he spent 5 hours at ACDC a month ago, waiting on his release, sometimes there is PAD actually picks people up from jail. So if Your Honor could see your way clear to doing it as a program instead of a 8 month revocation, that would be super. And if the court is inclined that way, which we would ask for, then we could specify perhaps to be released tomorrow instead of tonight, and that would facilitate the transition to a smooth situation.
All right, I know pretrial is on. Can I get the history from Mr. Posey, or the state can give me the history, whichever?
Yeah.
One moment, Your Honor. He's on the probation calendar?
Yeah.
Yes.
I don't have one. What is his first
Mr.
name?
Posey.
Michael.
That's okay. Deputy Falk, do you have the history at all?
Your Honor, I had to log off briefly, so I'm logging back on. I can get it shortly, but I just need to log back on first. But I do have a question. Has PAD been reached out to about this defendant going back into or working with PAD?
Yes, Mr. Hogan is with PAD.
Mr. Hogan is there. Mr. Hogan, can you
Yes, ma'am.
turn on your mic? Yeah. Can you tell us what the status is for Mr. Posey?
Of course, and I can provide some more detail if you like, but I'll try to be very concise. I was in the parking lot at DFAX when the public defenders reached out, and the reason is because, as I said, about 30 days ago, the record will have the exact times, Mr. Posey had been released. I think it was still Judge Davis at that point. And I ended up about 5 hours waiting for his release to jail when the captain came down and said the present hold would not have him released. The status that day was a release into PAD's custody. But what that really means is the whole purpose is that Mr. Posey was working very hard with us to get into what I would consider a serious drug and alcohol rehabilitation program. And I work with Douglas Whitaker, the program director at Salvation Army, and Doug was staying late that day to receive Mr. Posey in. I have to point out to the court and the other participants in this hearing that we did not know that Mr. Posey would be on today. So I haven't talked to Doug, but I'm quite confident that they're just as willing to take Mr. Posey now as they were a month ago. I probably should say I need to check with Doug with a phone call. I do believe, again, so the direct question was Tad, yes, we want to assist Mr. Posey. He's been accepted as a participant in our program, and we were waiting on the outcome of this court action in the Fulton County Court. Are there other questions and any other way I can assist, Your Honor?
I think Deputy Falk may have a question, but I think he did pretty good answering all of our questions.
I do as well, Your Honor. I think that answers my questions. The state doesn't have any follow-up questions for Mr. Hogan, but let me look, now that I'm in our Odyssey, let me look at the defendant's previous history.
Okay.
I got 2 more coming. Hey, I'll say you got 2 more coming. Hey, John.
Okay, Mr. Posey has several open cases, it appears. Let me look at his. Okay, so subsequent to this case, Mr. Posey has an additional 2 open cases. From what I can see, he has a total of he has a total of 90 plus cycles. We are seeing, sorry, I'm going through actually 108 cycles, Your Honor. And from what I can see, his most recent history, he has 2 open cases currently in our office, as well as a 23 SC 18556 case out of Superior Court for theft by shoplifting, 23 SC 18585 for criminal trespass, burglary in the 2nd degree, and theft by taking. And again, those 2 open cases, and I can get those case numbers for Your Honor with us. So we're showing 2 open cases in felony division and 2 open cases in our division.
Okay.
And if you want to, Your Honor, I can probably add to that.
Okay, go ahead, pretrial.
In the last 10 years, he has at least 5 violations of parole. He has a felony conviction for terroristic threats and acts, another felony conviction for terroristic threats and acts, criminal trespass, 2 counts of criminal trespass. He has another felony conviction for terroristic threats and acts. He has at least, let's see, 1, 2, 3 violations of probation. Three FTAs and an additional 1, 2. Let's see. He has a misdemeanor for disorderly conduct, simple assault, and another misdemeanor for, let's see, simple battery that was amended from an aggravated assault. And that was in 2021.
Okay. I don't know.
And that's just within the last 10, that was history within the last 10 years.
And Your Honor,
Right.
he is also on today's calendar for the competency calendar, positions 21 and 22, as well as 23 and 24.
Oh, I see.
So if possible, I would like to address this kind of holistically along with Mr. Howard at the competency calendar. I'm not sure.
Yes.
There's a number of things that need to be resolved here, not just this.
Right. Mr. Hogan, he's got a myriad of concerns here for me as well.
Would the cases on the competency calendar be among the two cases you mentioned that are open misdemeanors?
That is correct. Those are positions. It's 23 CR 002357C, fair evasion criminal trespass, 23 CR 001669C, criminal trespass, 23 CR 000078C, criminal trespass, and then there is a 2006 case that is also on the calendar.
May I be heard briefly, Your Honor?
Yes.
It is simply to say this. It is, of course, not my job today to advocate regarding the legal issues. Obviously, very well prepared and very capable counsel on both sides. As I hear this list in the priors, anyone familiar with the court systems would kind of go, oh my goodness. What I hear is mostly, not only, but mostly what PAD calls crimes of survival. Again, it is not my intention nor my place to respond to either lawyer's arguments. They're very capable of doing that. I will simply say we were aware of extensive criminality that we judged to be, again, mostly in the nature of crimes of survival as opposed to just, let's say, perhaps more serious things. I did listen carefully to the prosecutors and the clerk's recitation of the past. I will simply say that our role and the way that PAD has been invested by the significant players in the court system here in Atlanta is to try to help men and women break those cycles. I feel confident in Doug Whitaker's program at the Salvation Army. And what would happen if at any stage in this proceeding or these other cases that you release him to us and with the condition that he complete Mr. Whitaker's program, what would happen is two things. Initially in that program, he would have to meet some rather strict requirements that would focus on his spoken addiction, alcohol addiction, as well as what we'll call just improving habits of responsibility. But just as important, what PAD will then do is follow up upon his release from Salvation Army to be sure that, you say a shoplifting case. I presume most people in Atlanta shoplift because they're hungry. We can meet those day-to-day needs, and that is our responsibility. It would be upon release from the program to help this gentleman get the things he needs and work step by step to get in a position where he can begin meeting them on his own, rather than having his food and housing paid for through taxpayers' money at the jail. So again, not my position to advocate. I get that there's complicated legal issues, and I will simply say that we feel that everyone's redeemable. However, gentlemen and women who have the kind of extensive history that Mr. Posey has, there's a reason that PAD was created, and it's to try. We can never promise outcomes, to try to make a difference and break those cycles. With that, I'll stand mute for the rest of this hearing.
And Your Honor, let me just clarify. I'm just waiting for Mr. Howard to come online so we can address the rest of his cases and competency before we address the probation revocation. It doesn't fix it if we address this and not the other cases. So I'm just waiting.
We're trying to do this. Deputy Falk's word was correct holistically. Mr. Hogan, we probably couldn't have said it any better. And we appreciate your eloquence in stating that. And when Mr. Howard comes on, we just want to make one more check to make sure we've got all our bases covered. And then I will make my ruling and decision. You all sent a note to him, Deputy Falk, an
I
email
think-
rather.
Yeah, I can shoot him an email right now, just letting him know. I thought he would be on, but let me just shoot him. an
Yeah,
email
I
real
thought he
quick, letting
was.
him know that he needs to join us, and we can
Is he
address
still
that.
at the jail, Mr. McLean? Is he down there with you guys?
He's not in our room here, but he's got to be.
But he's down there somewhere.
Gotta be
Yeah.
here somewhere.
Usually.
Wasn't very many minutes ago. And let me mention too, Your Honor, I have, through the years, gone into the actual, building and talked to the program, people in years past when I was assigned to, accountability courts. And the particular program of Salvation Army that he'll be going to is the one that's, on Marietta, near, not the red shield down the street, but it's the one that's near where the engineer's bookstore used to be, and it's located before it went online. And that's a very good program. I've had clients go through there. Nobody can guarantee 100% success rate, but it's a good program.
All right.
And Your Honor, I just sent Mr. Howard the email, and with your consent, if we can address that first in the competency, then we can just move along with Mr. Posey's
along.
case, which will wrap everybody
Right.
up.
Right. I agree. There he goes.
There we go.
Hello, Mr. Howard. How are you?
Good.
You're the
good.
man
I
of
was
the
trying-
hour.
I
We're
was
waiting
trying to
on
time
you.
Things perfectly. I knew you had more cases on SAP, so I switched locations, and of course, you all would need me in between.
That's okay. We're
But
glad
I
you
was
did
able to
that.
hear
Okay.
on Google most of what was going on.
Okay.
So
With Mr. Posey. So he is on your competency calendar. Can you update us where you are? Mr.
Right, so
Hogan
do
with
we-
Pat
we can go to
has
breakout
really,
and discuss that if we need to.
you want to go into breakout? Okay. Mr. Jordan or Miss Grace, can you put Mr. Howard, actually Mr. Hogan, Deputy Falk, Mr. McLean, am I naming all the right players? And do we need Miss Harris in there as well? As well as ASG Jones?
There is Miss Monterio. She is going to be present for Mr. Williams' case on the competency add-on calendar.
Okay.
So Judge, let me get it right.
Okay.
That's you, Judge, Deputy Falk, McLean, Hogan, Harris, Jones, and Monterio.
And
Okay.
me? And me?
Mr. Hogan?
I got you, Mr. Howard.
Yes, and Miss Montero is my boss, by the way.
Oh, she's Mr. Hogan's boss. Okay, there's the
Yes, so
connection.
you're getting double teamed from Pat today.
Double team today. Okay, I tell you, that's great.
For my part of the breakout, could you send that to Samantha Adams, public defender?
Oh, I see.
Okay, Mr. McLean.
That'd be great. I'll borrow her. Thank you.
Mm-hmm.
And as a separate announcement for another breakout room, if I could have a laptop with, or excuse me, a breakout room with 4 North and my laptop to address position 2.
Okay. What did we do before laptops? I tell you.
Your Honor, we also have position 2, Mr. Allen on 4 North.
Okay, we've got him. I think, are we going to our breakout first? I thought we were.
Come on in here. Not you. You.
Ms. Graves?
I'm getting you now, Judge.
Okay.
Hello? Yeah. Yeah, and Charlie, yeah.
Thank you. Okay, that's not Mr. Posey, I don't believe.
I haven't. Good job.
I believe this, Mr. Posey.
Bless you, Judge, man.
No. Sit down. Just hang on, we both need to go in, okay?
All right. And Mr. McLean, I think, is walking.
Go ahead.
There he goes.
So I'll send in one of those petitions and sign off his 3-day waiver of prior notice on the probation hearing and scoot that over to JCS.
All right, Mr. Posey, you have a lot of people advocating on your behalf, willing to help you.
Yes, Your Honor.
So I'm not going to revoke you. Going to give you a chance.
Yes,
And
thank you, Your
so
Honor.
I wish you good luck with it and hope that everything works out for you. Okay.
God bless you, Your Honor. Judge Mincy.
All right. So we'll get the paperwork going and they'll tell you when and how to report and participate, and Pat will pick you up at some point. Okay.
When will they pick me up? So they'll get you.
Not 100%. It may be tomorrow, the next day. It won't be today. I can tell you that.
Okay, that's fine.
It won't be today, but they're getting you together and we're getting all the orders together so that can happen in the next day or so. Okay.
Okay, God is good. My Easter star. Thank you.
All right. Take care.
It won't be in vain. I'm gonna do the right thing. Stand
Okay,
up.
good. All right. Very good.
Stay sober. I'm
Yeah.
cool with that life.
Great.
You're doing me some justice. Thank you. I appreciate it.
All right. You're welcome. All right. Who do we have next?
Thank you. Take care.
Your Honor, next is position 14, Kendrick Melton. Mr. Posey, come on. Mr. Posey, come on.
Mr. Melton is position 14, 15, and 16.
Okay. All right. We have the 23, the FTA from January 19th. And then we have the 22 CR 00706-1A, criminal trespass, theft by shoplifting. And then we have 7377A, theft by shoplifting and criminal trespass from 10/23/22. But that's what we have. And it says hold for announcement. So what's your announcement?
Yes, Your Honor, Mr. Melton is going to take a guilty plea on both positions 15 and 16. Part of the agreement was that the FTA would go away once he enters the plea.
Okay. All right, state.
Yes, Your Honor. So on case ending in 7061A, which is a criminal trespass, well, they're both the same, but in that case, the state's understanding of the offer is going to be 12 months to serve 4 days, credit for time served 2 days, balance suspended, and then stay away from racetrack at 1180 Virginia Ave in Hateville. And the case ending in 7377A, the state's offer is 12 months to serve 15 days, credit for 4 days, stay away from that same racetrack, 1180 Virginia Avenue, a anti-theft course. And there was a mention of restitution, but I do believe that the items were recovered.
Okay. All right.
Yes, Your Honor, and also for the record, in the case 22 CR 00706-1A, Mr. Melton has actually served 3 days as of today. In the other case, 22 CR 00737-7A, he has served 4 days. And with regards to the FTA, which is 23 FTA 00635, he has served 7 days. That is a total of 15 days, Your Honor.
All right, that's what you have, state.
1 second, Your Honor.
Okay.
I actually have for the FTA, he's been confined 8 days, Your Honor. For the theft, no, that's all. The theft by shoplifting, this theft by shoplifting from the 1029 incident.
We got 1023 and 1017.
Yes, yes, Your Honor. That the one where he was released on 1029, that's the 1023 incident, I believe. Yes, 1023, 2022. He did 4 days on that. And then the 10-9, the one where he was the 1019, the 1017, he did 2 days on that.
Okay.
So
That's
I can
what
go
the
back.
calendar says, yeah.
Yeah.
Is that what you have, Ms. Adams?
I'm double checking. I have, it ends up being the same math, Your Honor. I had 3 days for case ending, I'm sorry, case number 22 CR 00706. 1A, that was the one with the offense date of October 17th, 2022. And I had 7 days for the FTA, but that 1 day, it just pretty much ends up equaling the same amount of 15 days total.
Okay.
Because I also do have 4 days for the other case, so that total is still 15 days.
I see ASG Jones looking.
Yes, Your Honor. I'm just trying to make sure that the FTA is attached to that, to the 7377A and not the 7061.
Oh, to the other one. Okay.
FTA is for case 22 CR 0073778.
You said it is?
Yes, and that's where he's currently holding on.
Okay. Well, we're fine. We're fine with giving him the 15 days credit for time, the credit for time served.
Okay. All right. And so, Mr. Melton, you're wishing to plead guilty?
Yes. Yeah.
Okay. And so let me swear you in. Raise your right hand for me. You affirm the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury.
Yes.
All right, you put your hand down. I need to ask you a series of questions. The first being, are you under the influence of any medication, drugs, or alcohol?
No.
Are you satisfied with the services and representation of your attorney?
Yes, I am.
And you understand that by pleading guilty, you're giving up or waiving your right to the presumption of innocence?
Yes, I do.
Giving up and waiving your right to remain silent and not testify against yourself?
I do.
And you're giving up and waiving the right for trial by judge or jury, whichever you prefer? Okay, and you prepared and agree to waive these rights today?
Yes, I do.
Has anyone promised you anything to plead guilty?
No, ma'am.
Has anyone told you receive a lesser sentence for pleading guilty?
No, ma'am.
And you understand that if you're on probation, your probation could be affected by a guilty plea here today?
Yes, I do.
And you are pleading guilty in both of these cases, freely and voluntarily with the full understanding of the charges against you?
Yes, I do.
All right, and so there's 2 cases, 7377A and 07061A, both with the same charges of criminal trespass and theft by shoplifting. Offense dates 1017 and 1023, 2022. So you're pleading guilty to all 4 charges. Is that correct?
Yes, I am.
All right. And looks like you're getting credit for time served. You've got to stay away from the racetrack on Virginia Avenue. Can you do that?
Yes, ma'am, I can.
All right, and then you've got your anti-theft force as well. And then you will be on probation for 12 months as well. And I think on the first one, it says balance suspended. Is that correct, Mr. Jones? Or is it probated? I'm trying to see.
Your Honor, my understanding is that on 22 CR 007061A, that's balance suspended, and then on the other one, it's balance probated so that he can go ahead and do the anti-theft class.
Okay. All right. That's your understanding, Mr. Jones?
That is correct, Your Honor.
Okay, I got it. All right. Good luck to you, Mr. Melton.
Your Honor, I do just have one request with regards to Mr. Melton. We would request that some of his probation fees, I didn't mean to ask this before, I apologize to the court and to the state. That some of his probation fees be waived and that his probation terminate upon completion. Mr. Melton is a retired truck driver and he receives Social Security because he's just on a limited income.
Mr. Jones, do you have any significant history?
1 second, Your Honor.
Okay.
What position was Mr. Melton again? I'm sorry.
He's number 14, 15, and 16. It's Mr. Melton, 14, 15, and 16.
Okay. So I'm showing he has 2 arrests in 2020 for possession of cocaine, possession of a firearm in 1998. I'm showing a possession of marijuana, small amount in which is a conviction for possession of marijuana, a small amount in 2003, and then a DUI from 2003.
Those are over 20 years, Your Honor.
Okay. I will not waive any fees, but I will let him go non-reporting after he's completed the anti-theft course.
Okay, thank you, Your Honor.
Uh-huh. All right. Who do we have next?
This is Jamel King on the probation. And after him, we're gonna go to position 2, Allen.
Mr. Jordan, let's see.
And I believe Mr. King was an add-on to the probation revocation calendar. I don't know if a formal add-on calendar was sent out.
I'm thinking not. Let's see.
But we do have the source on Zoom.
Mr. Jordan, you may have to sound for me because I don't think I received that case. Unless it came this morning. Oh, hold on, let's see.
My judge. Sorry about that. My camera had off for a second. But the case is 15 CR 002341. Jamel King, and it's a simple battery BV charge that he was on probation for.
Okay. All right, what do we have? Ms. Harrison, probation?
Yes, Your Honor. Probation recommendation is just the time served his case, since this was a case back from 2015.
Okay. All right, anything else, State? or anyone else?
Nothing from the state, Your Honor.
Okay. All right, I will not revoke him. I will go with the recommendation of probation. And give him credit for time served. Is that Mr. King in Fort North?
Yes, ma'am.
Yes, Your
Okay.
Honor.
Yes,
All
ma'am.
right. Good luck to you, Mr. King.
Yes, ma'am. Thank you, ma'am.
That concludes my business, Your Honor. May I be excused?
Yes, you may. Thank you, Ms. Harris.
And my apologies, Your Honor. I was trying to get on the Zoom to tell you that we were agreeable to that, but I am
understand.
currently in the library at a seminar, and so my computer is not
Oh,
acting.
yeah, I thought they said you were gone, but you popped in, so thank you.
Not a problem. And I'm here for the competency calendar, so.
Oh, okay.
This is position 2, Mr. Allen.
Hey, Duffy, let me do position 29. He's the last one in courtroom 2.
Okay.
We got, what was that said?
Oh. Sorry, Your Honor.
Uh-huh.
I thought we were done in courtroom 2, but we do have a couple of more after position 29.
Okay. 29 is Tolliver.
Yes, Your Honor. Tylen Tolliver is case number, let's see, 20 CR 5954H, correct?
Correct.
And Your Honor, this is simply going to be a 12 and a 60 and a 9. So that's going to involve a little extra jail time. And he asked the court to accept his negotiated plea of guilty.
Okay. All right, I will do that. State.
Yes, Your Honor. So the state's recommendation is 12 months to serve 60 days, credit for time served 9 days, balance probated, 40 hours of community service, and restitution in the amount of $85.54.
All right,
And
your
the state-
understanding. Oh, go ahead.
And a stay away from 2840 Buckner Road.
Your understanding, Mr. McLean.
Yes, Your Honor, those are the terms that I conveyed to him yesterday. And he says he would like to accept those terms.
All right. And do you so stipulate?
Yes.
All right. Mr. Tolliver, are you ready to take your plea? I'll swear you in. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right. Ask you a series of questions. First being, are you under the influence of any unprescribed medication, drugs, or alcohol? All right. Are you satisfied with the services and representation of your attorney? And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, Your Honor.
And that you're giving up and waiving the right to remain silent, and not testify against yourself?
Yes, Your Honor.
And that you're waiving the right to trial by judge or jury, whichever you prefer?
Yes, Your Honor.
Has anyone told you receive a lesser sentence for pleading guilty?
No, Your Honor.
Has anyone promised you anything to plead guilty?
No, Your Honor.
You understand that if you're on probation, your probation could be affected by your guilty plea?
Yes, Your Honor.
And you offer this guilty plea freely and voluntarily with the full understanding of the charge against you, correct? All right, I will accept your guilty plea to criminal trespass and damage to property. And so you do understand the conditions of your probation, correct?
Yes, Your Honor.
All right. Good luck to you.
So was that a stay away, Judge? Sorry.
Yes, stay away, 2840 Butner Road.
And are they going with the restitution or no restitution?
The restitution as well.
Yes.
Okay, so can you email me who the restitution is supposed to go to? I'm gonna need a name and contact
Right.
phone number for probation.
I can send it in the chat really fast if that's faster for you.
Oh, that's
Yeah.
fine. I can write it down for probation.
Okay.
Yeah.
Are we ready for the next position?
Yes, sir.
Position 2.
31, Tanya Wilkes.
I'm sorry?
31, Tanya Wilkes. Is that what we're doing?
Ms. McLean, I need to do position 2 and get off this floor.
Oh, get up.
Okay. That's Arctic Island, 23 CR 004507C. Is that correct, Deputy?
Yes, it is.
Okay.
And Your Honor,
Mhm.
I was able to speak with Mr. Allen, so the announcement will be that this is a negotiated plea.
Okay.
The state's offer, Your Honor, is 12 months to serve 18 days, credit for time served 9 days, balance suspended, and a stay away from 29000 P Street Road, Northeast Atlanta.
Okay. Your understanding, Mr. Dotis?
Yes, Your Honor, and I did convey that to Mr. Allen. He understands, and he's also clear that that address is the Chase Bank, that he needs to stay away from that bank. We do stipulate to the factual basis, venue, and ID.
All right, Mr. Allen, you ready to take your plea?
Yes, ma'am, I am.
All right, raise your right hand for me. You affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down. Are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am, I do.
And that you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
Has anyone told you receive a lesser sentence if you plead guilty?
No, ma'am.
And do you understand that if you're on probation, your probation could be affected by a guilty plea here today?
Oh, yes, ma'am. I'm not on no probation.
Good. All right. And that you again offer this guilty plea freely and voluntarily with the full understanding of the charges against you.
Yes, ma'am.
All right. So to all 4 charges, you plead guilty. Is that correct?
Oh, it's red.
Criminal trespass, disorderly conduct, and willful obstruction. 3 charges. I'm sorry.
Okay, yes, ma'am.
3 charges. I apologize. And you understand your conditions to stay away from Chase Bank.
Yes, ma'am.
All right. That is it. Anything else, counsel?
Nothing from the state, Your Honor.
All right. Thank you. Good luck to you.
Yeah.
All right, Your Honor, we're going back to Tanya Wilkes.
31.
Position 31.
Okay. So we were holding, what are we doing there?
This is a negotiated plea, Your Honor.
Okay. State.
Yes, Your Honor. State's plea offers 12 months to serve 30 days, credit for time served 15 days, balance probated, no further contact with Kayla Bain, a stay away from 300 Fisk, F-I-S-K, Drive, anti-theft class, and 40 hours of community service.
All right. That's your understanding, Mr. McLean?
Your Honor, those are the terms we expected to hear, and we do stipulate.
Okay, good. Ms. Wilkes, are you prepared to take your plea now?
Yes, ma'am.
Okay, raise your right hand for me. You affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Okay, kind of speak up for me, can't hear you.
Yes, ma'am.
All right, and are you presently under influence? You can put your hand down. Are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am. Sorry.
and that you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And you understand that if you're on probation, your probation could be affected by the guilty plea.
Yes, ma'am.
And you offer this guilty plea freely and voluntarily with the full understanding of the charges against you. Is that correct?
Yes,
Or
ma'am.
the charge? It's one charge of theft by taking, correct?
Yes, ma'am.
And you're pleading guilty to that. Is that correct?
Yes, ma'am.
All right. And so you understand, I heard the conditions. You can stay away from Fish Drive and no further contact with the victim, Kayla, and I didn't write the last name down.
Bain, Bayne.
Bayne. So you can do those conditions, correct?
Yes, ma'am.
All right. Good luck to you. I accept your plea.
Thank you.
Thank you.
Uh-huh.
Yeah.
Yeah.
All right. Who do we have next?
I think, Your Honor, we might be complete with the SAP calendar.
Okay. Is that it?
That is
Mr.
all.
Jordan?
So do you want us to reset position 9 to next week? Mr. Glover, it said that jail was unable to locate.
Yes, I had a chance to speak with Mr. Glover for position 9. I was gonna announce it when we went over the calendar. It's gonna be a 1-week reset, so we can have a social worker meet with them.
Okay. Thank you. That's August the 10th.
Okay. And I had one other one, I think, too, and I guess they'll tell us later. Did we do 32?
I think we did. He made bond.
32. He made
So
bond?
32 to
Okay,
33 is the same made bond.
okay, gotcha.
And then on position 6, it said not guilty waive presence. Are y'all waiving the arraignment on that case?
Yes, and I'll submit a written waiver of arraignment and acceptance.
Okay, thank you.
Okay.
Now, who is this,
I think that's all I have for the regular SAP calendar, Judge. If you want me
Okay.
to go up before we do the competency calendar breakout.
Yes.
Yeah.
And then you can tell us about 13. That was the only other one I didn't have anything on.
So position 13. That's the one that we're resetting to 8/10/23 SAP.
Okay. All right.
Position 1, I have a plea. Position 2 is a plea. Position 3 is on the competency calendar. Position 4 was a non-negotiated plea. Position 5 was a plea. Position 6 is a not guilty plea, waive jury. Position 7 is a plea. Position 8 is null pros. I need a null pros order. That's the FTA case. Position 9, reset 8/10/23 SAP. Position 10 is a plea. Position 11 was an Alfred plea. Position 12 was a plea. Position 13 is reset 8/10/23. Position 14 is a null pros. I need a null pros order for the FTA case. Position 15 was a plea. Position 16 was a plea. Position 17 is reset jail jury. Position 18 was a non-negotiated plea. Position 19 is a null pros. I need a null pros order for the FTA case. Position 20 was a non-negotiated plea. Position 21 was a nolo plea. Position 22 was a not guilty plea, waive arraignment. And it's a amended bond order for $2,000 surety. Did you want all the conditions to remain the same on that order, Judge?
Yes.
Thank you. Position 23 is reset to August the 10th, 2023, SAP, waive arraignment. Position 24 was a plea. Position 25 is a null pros, need a null pros order for the FTA case. Position 26 is a plea. Position 27 was a plea. Position 28 was a plea. 29 and 30 were pleas. 31 was a plea. 32 and 33 made bond. 34 and 35 were pleas.
Okay. Sounds good.
So we just have the competency count left.
Right.
Judge, are you guys ready for the competency calendar
Yes, ma'am.
breakout room?
Yes, thank you.
Hello, Miss Grace. Miss Grace, are you available?
Miss Grace, are you still there?
Yes,
Are they still in the breakout room?
yes, they are.
They are. Okay, just
Yes,
sure. Thank you.
no problem.
Hey, Melissa. Melissa Grace, Paige and Melissa Grace.
Yes,
Hey, make me the host. If
Okay.
not, you're not gonna be able to start the next meeting.
okay, I was gonna come in action. Okay, I will
Thanks.
do that now. Wait a minute. Lord, I can't see me close. And then I'll be able to sign off. Michael, I'm good.
Let's see here.
'Cause I don't know if
Yeah,
I-
yeah, you can sign off now. Yeah,
Okay.
you can sign off. You're good.
Okay.
Okay.
And you'll be able to do the converting and everything?
Right.
Okay. So I just closed this whole meeting out.
No, it should just say leave.
It do, I just say leave.
Yeah, so you're good.